Good evening, everybody. I'd like to welcome you to the March 24th, 2009 Howell Township Council regular meeting. I'd like to call the meeting to order. Ms. Wallman, would you please read the opening statement?
Certainly. Let the minutes reflect that adequate notice of the holding of this regular meeting of the Howell Township Council was provided for in the following manner. By the posting of a copy of said notice upon the bulletin board in the Township Municipal Building on January 2, 2009. By the faxing of a copy of said notice to the Asbury Park Press, Tri-Town News, and Star Ledger for publication on January 2, 2009. By the filing of a copy of said former notice in the Township Clerk's office on January 2, 2009. The public will be allowed to attend and will be allowed to participate pursuant to the Open Public Meetings Law. The public is reminded that civility and decorum will be maintained during the meeting. Any contracts awarded at this meeting and between now and the next meeting will be required to comply with the requirements of Public Law 1975, Chapter 127. In accordance with the Fire Prevention Code, be advised that this facility is designed with 3 emergency exits for your safety. The locations are as follows. Upon exiting the meeting room to the rear, they are to immediate left and immediate right, and at the front of the meeting room at the left of the dais. Furthermore, smoking is not permitted in the municipal building. Please take note that this meeting is being videotaped for possible future broadcast on Howell Television. Roll call, Mrs. Clark.
Here.
Mrs. Dalton.
Here.
Mr. Howell.
Here.
Mr. Memolo.
Here.
Mayor Walsh.
Here. Mr. Schlegel, I believe we have reason to go into executive session?
Yes, sir. Personnel and litigation.
Okay. For the benefit of the public, we will return approximately 7:30.
Mayor, I'm going to just read the executive session resolution.
Would you please?
Yes, whereas the governing body of the Township of Howell is authorized pursuant to NJSA 10:4-12 to exclude the public from that portion of this meeting for purposes of discussing specific matters as permitted by NJSA 10:4-12, whereas the governing body of the Township of Howell intends to discuss certain matters which are deemed confidential pursuant to NJSA 10:4-12 in executive session, whereas at this time the governing body of the Township of Howell cannot determine the time when the discussion to be held in executive session will be made public, but will disclose the minutes of the executive session when the need for confidentiality no longer exists. Now therefore be it resolved by the governing body of the Township of Howell that this meeting shall be adjourned to an executive session and the public will be excluded in order that the governing body of the Township of Howell may discuss the items previously listed. We need a
Can I have a motion to go into executive?
So moved.
Second it.
roll call. Mrs. Clark?
Yes.
Mrs. Dalton?
Yes.
Mr. Howell?
Yes.
Mr. Memolo?
Yes.
Mayor Walsh?
Yes. Now, we will go into executive session and return approximately 7:30. I'd like to reopen the meeting. It's a regular Township Council meeting. March 24th, we all please stand for the Pledge of Allegiance.
Pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
We all remain standing, please, for one moment of silent observation for our troops that are fighting all over the world for the freedom which we enjoy. First thing on the agenda, acceptance of minutes of the previous meeting.
I'll make a motion,
Executive
Mr. Mayor.
Motion to accept.
I will second that.
Can I have a roll call, please?
Mrs. Clark?
Yes.
Mrs. Dalton?
Yes.
Mr. Howell?
Yes.
Mr. Memolo?
Yes.
Mayor Walsh?
Yes. First thing on the agenda this evening, we have a presentation of certificates of graduation to the CERT class to members of the PAL from the Office of Emergency Management. I'd like the council to join me down front with the OEM coordinator, Mr. Ron Sanasek.
Thank you. I'd just like to say a few words. First off, Mayor, Council,
Manager Schlegel, and everyone else here tonight. Thank you for letting us come here to present these certificates. Some of you may have seen other CERT classes that graduated. They were all adult classes. They were mostly affiliated with the schools or one other community. I'm proud to say that Howell has been the leader in the CERT. It stands for Community Emergency Response Teams. It's a training of 8 modules in areas from fire suppression to terrorism, or response to terrorism. We don't want any terrorism.
Okay, Bob. Okay.
Emergency medical and other areas of emergency response. We have some of the finest instructors going. Captain Jeff Mayfield presents the response to terrorism module. Holly Talene presents a disaster psychology module. My wife presents emergency medical. And Mr. Frank Bosjancic, who everybody calls Bosco, presents the fire safety. And I have to say that we were very honored to get permission from the state police to be the first teen CERT class in the state. And since we've led all along, it's only appropriate that we would be the first, so thank you. And in recognition of completion of the class, they get this fine duffel bag sponsored by the Department of Homeland Security at the federal level and the New Jersey State Police OEM at the local level. We have so far 180 people trained in this program, and these fine young people will be adding to that list. Officer Hill, did you have something to say? Sergeant Hill, pardon me. I got captain right, that's more important.
I got demoted. I want to thank Ron and the town council. For most of you, you know the Police Athletic League has been responding to emergency disaster areas probably since 2005 when Hurricane Katrina and Rita hit. Our kids have been down in New Orleans and the Gulf Coast region, but also helping here. We have some projects going on in town. We found some homeless people actually living in woods in town that we're working with now. But it's through the effort of these kids. These kids come out, we don't pay them. Their reward is to work with us. And believe me, I give them a hard time. I believe one of these bags is for Emily Co-Francisco to help keep her room clean at home. But but I want to thank the town. I got to thank the chief of police because he allows this to happen. Captain Mayfield, Ron, and the town council, and Township manager Helene, because she's done some amazing things for us as well. So thank you for all the support we've gotten through the town, and we appreciate all that you've done for us. Thanks.
Thank you. Mayor, would you like to call the names out?
The first one.
Chris Hill. Junior. There you go, Bob. Congratulations.
Thank you, sir.
He's not the one that left me laying on the floor.
No, that was Andrew.
Oh, okay.
John Louis. Congratulations.
Thank you, Mayor.
Maureen McBride.
We're taking to her baby.
Ariana Dunbar. I thought your name was Ari.
Thank you.
Christopher Hill.
That was Al.
Why'd you make me come up for years?
Good he makes you work twice.
That's it.
You do what you're told. No.
God bless. Shake your father's hand when you get a chance.
There you go.
Stephanie Leonard. Leonard? Congratulations again. Kristen Lehner.
There you go.
Thank you.
Congratulations. Thank you. The young lady that needs to clean a room, Emily Co-Francisco. When I was young, just closed the door. Jessica Kenny. God bless. Ryan or Rain? Ryan Smith.
Thank you. Congratulations.
Congratulations. Andrew Akonzo.
Andrew left Mike on the floor and being electrocuted. You wouldn't help Mike? Mike Howell was
I'd leave him there, too.
He gets 2 shirts.
Touche.
Congratulations.
Cassidy Brzezowski. I got spell check to my right. Congratulations. Francesca Russo. Benjamin Talcott. Congratulations, Benny. Courtney Hulley.
Courtney the Beast.
What's that?
Nice Irish guy, Tim Donahue. That is it.
Thank you. Thank you.
Thank you, sir. And I'd just like to add congratulations to these fine young people, and hopefully, according to Sergeant Hill, there will be additional classes coming out of PAL, and we're looking forward to that. I think this class is looking forward to playing the victims in the exercise drill. That was the best part, I think. And for anybody else here, a commercial announcement: if you individually or an organization or group is interested, we are the largest CERT in the state, and we're looking for more classes. It's a program where you protect yourself first, your family second, and then if you're available, help the community. It's a great program, and you get this great bag. So, Mayor, thank you.
Things will go wrong if we keep it down there. Would anybody like to come up and sit up front? There's seats up here if you'd like.
Oh, don't worry about it.
Would you mind shutting the doors, please? Would you mind shutting that door over there on the left, please? Next, we have reports of township officials. Councilman Howell, anything?
Nothing for me, Mayor.
Councilwoman Clark?
Mr. Mayor, I just would like to suggest that council consider adopting a resolution similar to what the freeholders have, and that is a resolution supporting the Assembly Bill number 3570, abolishing the Council on Affordable Housing. I understand that the council has passed, I think prior to my arrival, a resolution that certainly deals with this issue, but I would think that at this point, given all of the issues on affordable housing, that it would be appropriate for us to do something similar. I know everyone's received this in their packets, and I would like to see if we could pass something similar. As many people know, that the Council on Affordable Housing, with the third-round COA obligations, certainly have placed a lot of unreasonable obligations on the town. And I would think it would be one way that we can support that bill and get our view to the legislature to support that it should be introduced and should be passed, and COA needs to change. That's it.
Mr. Mayor.
Okay?
I think that's a great idea, and even though we passed that resolution a few months ago, I think we should pass it every week until they get the message. Maybe we could even put it on our website and ask people to sign on as individuals. Is there any way we could do that? Or ask, give people their legislators' information so they can, write themselves and say, my council passed this resolution, please, I urge you to support it.
We can certainly do something like that.
I'm fine with anybody else. Councilman Memlo?
I approve. That's what we should do, because this is all coming out of Trenton, and it has nothing to do with the council as far as what's going on in the town. Everything's been mandated towards us, and we're just following the law.
Did you have your direction?
We'll have it for the next meeting if you'd like.
Thank you.
On the reports of officials, anything, Councilman Memlo?
Nothing to report, Mayor.
Deputy Mayor?
No remarks, Mr. Mayor.
I have nothing myself at the moment. We'll go to hearing of citizens at the moment. One thing I would like to say up front, we will be going into the ordinances later on. If you're here to speak about the ordinances, I would appreciate if you would wait till then. We only have a few citizens that would like to speak about some things in general. A few people have put down there that they're here to speak about ordinances that we'll be discussing later on. It will be a rather lengthy meeting, I would assume. Absolutely, Mrs. Smith.
Thank you.
Would you like to be down also, Mrs. Smith?
Not tonight, thanks.
Okay. Anybody else would like to go on just on hearing of citizens? Full name for the record?
Dave Schultz.
Sue, you wanted to be on now? Mike Gruber?
I
You want-
put it on there.
Oh, okay. I'm John Costigan. First on the list is Ed Liston, but you wanted to speak about the ordinance?
That's what I'm here for, Mr. Mayor.
Okay.
So we'll wait until the ordinance is.
I'll get you up later. Lester Schwartzman also is here about the ordinance that we're going to be talking about tonight, correct, sir?
Yes.
Okay. Cheryl Gambarella.
Good evening, Mayor and Council. Cheryl
Name again.
Gambarella. I am President of the Howell Chamber of Commerce, and I reside in Howell at 66 Newberry Road. I wanted to come before you and just ask what has happened with this Route 9 sewers. I know I was here 2 months ago, and that was going to be on the agenda. I don't know where you are. I know there was supposed to be a phase 2 and 3. I just wanted to know how we are. What are we going to do about getting the businesses in, the businesses that we want be more active than proactive? And I also just wanted to bring an article, just a short little, paragraph that was in the December 26, 2008 issue of the U.S. Weekend. And it was a featured story called Local and Loving It. And a study found that for every $100 spent in a chain store, $14 went back to the local economy. For a local-owned business, it was $45. Okay, the author of Big Box Swindle, and researchers with the Institute of Local Self-Reliance. The story went on to say that locally owned businesses buy a lot of services from other local businesses. So by buying from one local business, you're not only supporting that business, you're supporting other local businesses. So I just wanted to, it was an article that I thought was very interesting to know that for local businesses, the ones that we can bring in here, that we, are more active on, not just reacting to what's coming in, it's $45 that goes back to the economy. So, you know, if you can let us know what's going to go on with these sewers, what your ideas are for future Phase 2 and Phase 3, we would appreciate it with the chamber. Okay?
Thank you very much. Esther Schwartzman? That's for the AST, okay. Grace Abramoff?
Good evening.
Good evening, ma'am. State your
Great.
name and address, please, for the audience.
Grace Abramoff, 26 Glenmore Road. I read somewhere today, whether it was on the web or what, that a person's sign was removed from their property today regarding this meeting, that the code enforcement
That's
officer...
correct.
Okay. Do we have a sign ordinance in our town?
Yes, ma'am.
Okay. The sign ordinance referring to you need a permit to put one up?
Yes.
And is there a length of time in which a sign can stay up before it's taken down?
I'd have to look at the ordinance.
Political signs, how long?
I believe
30
it's
days,
30
60?
days before and 14
30 days
after.
before? And is there a fine for those signs that aren't taken down after 30 days?
I think it's 30 days before and 14 days after the election.
Okay,
I
and
have to check the penalty provision, but there might be.
I'm pretty sure there is. I would like to address this to Mrs. Clark and to Mayor Walsh. You have a political sign on Herbertsville Road, right by the horse farm, just before Blewett's on the right-hand side. As of Saturday, it was still up, and I hope the code enforcement takes it down and fines you. Thank you.
All right. Listen, everybody. I didn't know it was there. I would have taken it down. All right, I'll take care of it tomorrow. I'll take care of it tomorrow. But everybody, please, let's all stay civil tonight, please. Let's all stay civil. I'd like to ask the council, before I call up the next person, I would like to shift 8A2 to after the other 8A items so we can get them out of the way.
Fine with me, man.
It's a move on my part, Mayor.
I have no objection, Your Honor.
Deputy Mayor?
I would agree, that's fine.
All right. For the record, we're going to shift ordinance number 882 to after we get done with the other ordinances. Next, Barbara Dixell.
Good evening, everybody.
Good evening, Ms. Dixell. State your name and address, please.
Barbara Dixell, The Villages, Howell Township. I just have a short report from the Teeticong. I just want to ask a question before I do that. Do we have an ordinance in Howell, and I thought I remember we do, about adult signs all lit up, adult store signs lit up? I thought at one point we did. That neon, I thought at one point they remember discussing it. At one point, the signs that are all.
I don't think it's necessarily limited to adult signs. I think we have a sign ordinance in place that addresses neon signs generally.
I thought that was, well, anyway, I thought that was a topic that came up regarding that particular area of things, because they're all lit up and advertising all over on their store windows. All right, anyway, okay, to Mayor, Council, Deputy Mayor, Colleen Schlegel, Bruce Davis. I spoke with Rob Carl, Brick Utilities, this week, who advised me that Brick is working with the DEP on a project to protect the Metedeconk River watershed with a watershed protection restoration plan. I'm going to give you this report. I'm going to give you a copy of the portion of the map that is part of Howell, that is part of the Metedeconk watershed. As you're aware, from the Muddy Ford Brook to Candlewood in this part of Howell is the sub-watershed of the Metedeconk River watershed. Haystack Brook and the Muddy Ford Brook are the two main waterways in Howell that meet at Quail Creek and then flow directly into the Metedeconk River. All the rest are connecting brooks and streams. Dix Brook, Alexander Avenue, Randolph Road, Arnold Boulevard, Ramtown Greenville Road, Newton's Corner Road, Herbertsville Road, Georgia Tavern Road, Maxim Southern Road, Lakewood Farmingdale Road, Easy Street, Lanes Mill Road, Oakland, and Victory Road are all part of Howell Township, but are also part of the sub-watershed of the Metedeconk River watershed. Route 9 south from I-195 to the Metedeconk River is also part of this watershed. There's a very small part of the Manasquan River in the upper right-hand corner of this map that flows through I-195 into a very small part of this Metedeconk watershed area, but of course that is not part of the Metedeconk watershed. When Mr. Rob Carl's project gets closer to starting, he will reach out to the townships. Thank you. Sincerely, Barbara Dixell, a member of the liaison to the Metedeconk Watershed Protection Alliance. Thank you.
Thank you very much, Mr. Dixon.
Thank you.
And as I said, as I get to speak to him, something that I'm allowed to report on, I will.
Thank you. Sue Weitengruber.
Suzanne Weitengruber, 25 Princeton Drive. At the last meeting, the council voted on a 4-1 vote to introduce the repeal of the hotel ordinance. I was wondering, was a legal advertisement placed for that? I guess that's something...
I can answer that. It was never introduced. It was pulled from the agenda prior to a vote to introduce. There was a 4-1 straw poll taken under a discussion item only.
And is that the reason it was pulled?
No, it was pulled prior to the meeting. It was pulled. There was never an introduction on that ordinance.
So the 4-1 vote was under discussion?
Under discussion items, yes, ma'am.
The 4-1 vote was actually unrelated to the item that was pulled from the agenda. There were two different hotel issues. Well, the one that we saw under discussion was repeal the hotel ordinance. Is the council contemplating introducing that? No? Yes? We don't know?
I think I've a couple times voted to repeal the hotel ordinance.
Well, if there was
some clarification that we needed, okay? And will it be coming up again? I would think so.
in a month, 2 months this year?
Yeah.
Okay, so the repeal of the hotel ordinance, which many of us sat in the audience and thought that you were introducing it, then it wasn't a repeal. We have to go back and listen to the tape, because a lot of us sat in the audience and thought that's what had been done.
No, that's on the agenda was an item to repeal a provision of the motel section of the ordinance. That was pulled. The discussion item concerned the conditional use, the definition of a hotel and conditional use. I think it was worded improperly on the agenda, but there was a discussion as to whether or not that actual provision should have been repealed. There was a vote and I believe it was 4-1 that they said they would like to see it repealed.
But that was under discussion. They never introduced
Okay,
it.
so it was under discussion and they'd say they'd like to see it repealed. Could we hope that it will come back rather soon?
I can assure you it will come back.
Okay, thank you.
Dave Schultz.
Mr. Mayor, good evening. In reference
Judge,
to
please, for the record.
Councilwoman Clark's proposed resolution on the Council of
Excuse me,
Affordable...
1 second. Name and address, please, for the record.
Dave Schultz, 149 Yellowbrook Road, Farmingdale.
Thank you.
In reference to Councilwoman Clark's proposed resolution on abolishing the Council of Affordable Housing, I would like to applaud her thoughts and efforts in that. The road's getting pretty rocky here. In speaking with an attorney that represented me in the case of Homedale Builders Association versus the Township of Homedale, Thomas Carroll advises me that the only way to get rid of the Affordable Housing Council is to have a constitutional amendment to be put on a gubernatorial ballot. So if anybody would like to entertain any ideas in that regard, that's what we're looking to have, like, this is what the people are going to have to do to get rid of the Council of Affordable Housing. And I'll tell you, they are really getting big and powerful. Mr. Mayor, thank you for your time.
Thank you.
Thank you. Don Smith.
Yes, good evening.
Good evening.
Don Smith, 54 Vanderveer Road in Howell Township. I just want to take the opportunity to thank the workers of the TWU in Howell Township who gave up so much. At that last meeting you had, the public meeting, you ratified their contract. And, you know, that's Howell pulling together. And I don't think many communities are fortunate enough to have the workers that this township has. Also, I don't think they get enough thanks from the public, from the citizens that they work for. You know, I was in a union shop. I served as shop steward for over 25 years with the United Service Workers of America. I was very fortunate. I never had to bite the bullet that they had to go through. My contract negotiations went rather smooth compared to the times that these gentlemen and ladies faced. And I got to tell you, that was, to me, that was quite a feat for a union to give, not only give back, but they took a beating that I think everybody pretty well understands that they took the hardest hit of anybody in the township, the TWU workers. And I think every resident of Howell Township owes them a great deal of respect and thanks. I also want to bring up it's Resolution 7A13 declaring gypsy moths a public nuisance, and I hope you will support the gypsy moth spraying program. I would hate to see us end up like Jackson did a number of years ago and completely defoliated. And that's really all I have at this time. Thank you.
Thank you.
Thank you, Mr. Smith. I agree with you. I was very happy that the contract was finally settled with the TWU. I think they stood up, listened to what's going on, they see what's going on around them. But Mr. Smith, I think because of those contracts going so smooth years ago is part of the reason we're in the situation we're in today. And I think we're seeing it all over the United States of America. All of a sudden, all that shuffling of money, now it's come back to roost. So. But I do commend the workers. We have a great workforce. We're done as far as that goes until we get to the... Mr. Costigan, I'm sorry. I wrote his name down, but I wrote it in invisible ink. No problem, Mr. Costigan. I'm sorry. Thank you, Mr. Smith.
John Costigan, 214 Birdsall Road. And I thank Mr. Smith also, and I thank the mayor and council for allowing me to speak. I'm glad to see Mr. Schultz is in the audience because I may have an answer for him. Being a partisan political person that I am, Republican, one of the ways we might be able to do something is to elect a governor. But by the way, this year, the governor will have the opportunity to appoint or reappoint 4 New Jersey State Supreme Court justices. 4. There are 7 on the court. And if you go back with the COA and the Mount Laurel decision in the early 70s, I think I was on a planning board in Hazlet at the time, we didn't realize the full impact until Mount Laurel too. And then again, the same radicalized Supreme Court in a couple of years ago decided that the Abbott districts were a good thing. And it wouldn't be so bad if there were any kind of appreciable increases in scores in those districts, but there aren't. So it's just throwing a lot of money that maybe should be, that our school board of education is not getting anymore in the same number of dollars that we were getting. One way is to elect a governor that will appoint or reappoint, well, I don't know if he'd want to reappoint, 4 strict constructionist judges, because that's the only way you're going to stop these harebrained, wacko schemes coming out of the New Jersey State Supreme Court. That's what brought us COA, and that's what's bulldozing our land and putting a lot of houses out there to the detriment of the open space that we happen to enjoy here in Monmouth County and in Howell. Thank you very much.
Thank you, Mr. Koski. Would any members like to speak on any of the consent agenda items that are on the agenda?
Mayor, I just wanted to remind you that we do need to open it up for a public hearing on the Resolution 7813, declare Gypsy Moth as a public nuisance. It's possible that the Public Works Director, Jeff Kramer, is present this evening to speak to you on that matter.
Is he here?
Yes, he is.
I can't see that far without my glasses, sir.
Actually, Mayor, if you want to open up for public comment, and then if there's any questions, Mr. Kramer will be here to answer.
Like to open up the meeting to the public. Would anybody like to speak? Mr. Kramer, would you like to speak on 7813?
I think he was just here to answer
He's just here to answer questions.
Would anybody like to ask out of DPW any questions?
Well,
Don Smith, you sure you don't have a question for Mr. Kramer? You stayed out tonight.
I just support it, that's all.
I'd like to close the public portion of the meeting. Let's go to consent agenda items. Need a council person to make a motion to either accept or does anybody want anything deleted from consent agenda items?
Mr. Mayor, there were a couple of items that that were not workshopped previously. I'm not sure if I had a couple of questions. I'm glad on 7826 to see that we are no longer disclosing private information about citizens who use our ambulance emergency response service. I always look at that, and Mrs. Schlegel, whoever fixed that, I thank them.
Mr. Filiatro, I'll thank on that.
That'd be Mr. Filiatro.
I think it's important on 7828 that we just understand what the risk manager is and why we need one.
That was part of the appointment of, I believe, the Danskin agency, who oversees your general liability. That is, if somebody slips and falls, your harassment policies, whether or not you have proper insurance for the vehicles. It's required that we appoint a risk manager. We did not do that at the last meeting, so this is more of a housekeeping procedure.
It's not any additional expense that we haven't budgeted for or anything like that. Is that correct?
That's correct.
and may I ask if we do not? Are we going to have some liability there? What will be the issue in terms of we do not have this in place? If Mr. Filiatro can.
The risk manager is kind of our liaison between the joint insurance fund and the township, and they one of the main things that he does is ensure that any weaknesses or problems that are identified by the safety committee of the joint insurance fund, that he coordinates the correction and everything. And we're required by the bylaws of the joint insurance fund to have a consultant to serve in this capacity. In the past, there has been BGIA agency that we have have appointed along with the, the renewal of the JIF. This past year, late in '08, we appointed Danskin Agency, and as housekeeping, that term did not include 2009.
Okay, thank you.
Any other questions on the 7As?
Yeah, can somebody explain 7A33? We're rescinding waiver of connection fees for properties along Route 9?
Mr. Filiatro?
Yes, when Route 9 sewer, the Route 9 sewer extension became active, council had adopted a program to waive one connection fee, which allowed a single-family residential to hook up for no connection fee. And we had talked at that point in time over a sunset clause. There actually was a statement in the letter we sent out that gave them 1 year to connect, but the actual resolution that waived that fee did not have the sunset clause in it. So we want to, we're asking that council formally rescind that and I think it's as of April 30th. We sent out a letter giving people last chance to hook up now without having to pay that one additional unit.
And you're certain that all residential properties affected by this have gotten the notice? You're satisfied that we did that?
The letter, the notice that went out to telling people hook up now, get your application now, or will expire on April 30th, went out to every lot and block that we have in that area by regular mail and by certified mail. So yes, they all have gotten it.
Go ahead, Deputy Mayor, no problem.
There are a number of grant applications on here, 7A29, 7A30, and 7A32. We had some discussion a few weeks back on another matter involving acceptance of a grant, and I just wanted to ask the same similar questions. Does this obligate us to commit matching funds, which we may have to discuss in our upcoming budget hearings?
None of these are matching grants.
So we just are accepting grants of funds. If the state has the funds available, I see some of these programs may not be continued.
Right, that's correct.
But that's all I have. Thanks
No
very
matching.
much.
Anybody else? Deputy Mayor covered every one of them?
She did great.
Mayor, if nobody else has any questions, I'd like to make a motion that we accept and approve 7A1 through 7A7, 7A13 through 7A17, 7A20 through 7A36, and I'd also ask that we include 7B1 through 7B6.
Need a second.
Second.
Have a roll call, please.
Mrs. Clark?
Yes.
Mrs. Dalton? Yes. Mr. Howell?
Yes.
Mr. Memelo?
Yes.
Mayor Walsh?
Yes. 7B7, we have appointment to Municipal Alliance Committee.
Mayor, I'd like to request that we appoint Ms. Sarah Whalen.
Do I have a second?
Second.
Have a roll call, please.
Mrs. Clark?
Yes.
Mrs. Dalton? Mr. Howell?
Yes.
Mr. Memelo?
Yes.
Mayor Walsh?
Yes. And on appointment 7B8 to Mobile Home Rent Control Board alternate park owner. Do I have any?
Mr. Mayor, I have an application here by the name of Stephen Gordon. Would like to make the motion that he be appointed to the Mobile Home Rent Control Board as an alternate.
Have a roll call, please.
Mrs. Clark?
Yes.
Mrs. Dalton?
Yes.
Mr. Howell?
Yes.
Mr. Memelo?
Yes.
Mayor Walsh?
Yes. 7C1. This is going to be a short little discussion. We received something today, a report from our Township Police Department about the traffic in White Street. Would you like to fill us in, Ms. Schlegel?
Sure, Mayor. Our Traffic Safety Division did a 45-hour window of analyzing the traffic along White Street. I know we had some residents that had mentioned at a previous meeting that they felt that there was extensive truck traffic along that route. So our Traffic Safety Division went out and did an analysis. in a 45-hour window, 925 vehicles passed over the counter, the traffic counter. Of those, 870 were noted to be passenger vehicles, which would include cars, pickup trucks, and SUVs. In addition, it showed that 55 vehicles at a length of 20 feet or more, which would be considered a commercial vehicle like a school bus or any other type of vehicle pulling a trailer, passed the counter. In breaking down that category even further, 30 vehicles between 35 and 40 feet in length passed the counter. The officer specifically notes that full-size school buses are approximately 40 feet in length. In addition, there were 9 vehicles that exceeded 40 feet that passed through the counter. What these numbers are essentially saying is that there is not a very heavy volume of vehicles on the roadway, as there are nearly 21 vehicles an hour on White Street near Conover Street. And that there was also a speed analysis done, and there was no indication that there is speeding on that road. Now,
Hold on. Listen. Please, everybody.
85% of all vehicles were traveling at 38. What the traffic safety feels is that in examining the area, that they feel that's a rural area, obviously with several horse farms along its length, as well as homes scattered along the Georgia Tavern Road section. There are no bridges or other overpasses which would require a weight restriction as required by the county or the state. They feel that truck traffic is not at the levels to warrant a restriction due to its volume, as 55 vehicles larger than passenger vehicles would potentially use the roadway in nearly a 48-hour span. They do not feel that there is a need for a weight limit to be imposed on White Street. However, what they do feel is that the resurfacing the condition of White Street is in dire need of being repaired, and that they suggest that resurfacing should be done in the areas of the poorest condition.
Anybody from the council? Ms. Nunziata, in our reports that we have about all our roads in Howell Township, any idea where White Street lands in the scheme of things, in the 185 miles or so that we have?
It's probably in the bottom third to bottom half. However, one of the considerations is if there's going to be any potential development in the area in the future, and you certainly do a restoration of the road if it's something that's going to be put down only to be taken back up. But it is in the lower segment of the road network.
Okay.
Lower meaning it's in the areas in most need of resurfacing?
Well, condition-wise, it's in the bottom, let's say the bottom third to bottom half. However, again, if you're doing 21 cars, per hour versus some other roads like Aldrich Road West where there's 5 or 6 or 7,000 cars, you have to weigh the usage of the road versus the condition.
So it's less likely to be repaired on our...
The approach we're going to take this year with our program, working with Rutgers, is that we're going to look at some of the busier roads and then some of the lesser busy roads that are in worse condition. So we're going to try to break it down into more areas than just the busiest roads.
Anybody else? Okay. Next, we'll go to public hearing on ordinances. First ordinance is 881. It's a land use to establish certain escrows for professional fees and associated municipal review of proposed developments would include affordable housing components. Ordinance number 09-8, introduced and passed on the first reading and published according to law, is now being taken up for further consideration of public hearing. Affidavit of publication of this ordinance in the Asbury Park Press issue of 2/2009 is submitted and is noted that a copy of the ordinance has been posted on the bulletin board of the municipal building. The copies were available to the general public upon request. Would you please read the title of the ordinance?
An ordinance amending the definition of township consultant set forth in the ordinance establishing certain escrows for professional fees associated with municipal review of proposed developments which include affordable housing components.
Now I'd like to open the meeting to members of the public. If anybody would like to speak on this ordinance? Nobody? Going once? Going twice? I'd like to close the public portion of the meeting. Would a member of the council like to speak about the ordinance at all?
Mr. Mayor, I think we workshopped this ordinance rather well, and the intent of it is to make sure that we are able to recapture some of the resources that we expend for professionals who are devoting their time to a specific application. And in that regard, we're not doing anything but making sure that those who are utilizing the resources of our professionals are paying the appropriate share. And I'm in favor of it.
Mayor, I'd also like to add to the Deputy Mayor's words that we are also now, by adopting this ordinance, allowing for the time spent by our employees as well as the outside consultants to be billed against that. Is that correct?
Yes, sir.
Right, that's what I meant by our professionals, meaning our in-house attorney, engineer, and anyone, whether in-house or outside.
Mr. Mayor, I would like to make a motion.
Go ahead.
I'd like to make a motion that ordinance number 0-09-8 be finally passed and adopted, and the notice of its passage and adoption be published in the March 27, 2009 issue of the Asbury Park Press by reference to its title only.
Do I have a second?
I'll second it, Mr. Mayor.
Have a roll call, please.
Mrs. Clark?
Yes.
Mrs. Dalton?
Yes.
Mr. Howell?
Yes.
Mr. Memolo?
Yes.
Mayor Walsh?
Yes. I'm going to go over to 883. Ordinance number 0-09-11, introduced and passed on first reading on 3/3/09 and published according to law, is now being taken up for further consideration and public hearing. Affidavit of publication of this ordinance, the Asbury Park Press issue of 3609 is submitted, and is noted that a copy of the ordinance was posted on the bulletin board of municipal building, and the copies were available to the general public upon request. Would you please read the title of the ordinance?
An ordinance amending Chapter 201 entitled Minors of the Revised General Ordinances of the Township of Howell to regulate tattooing and body piercing parlors, tattoo and body piercing artists within the Township of Howell.
Okay. At this moment, I'd like to open to the public. If anybody would like to speak about this ordinance. In order? You gotta go in order. Excuse me, one at a time. Please come up, sit down, state your name and address, please, for the record.
My name is Kevin Malone. I'm an attorney at law.
Into the mic.
Representing.
Into the mic, please. I'm sorry, or they can't pick it up.
Sure, it's okay.
Okay.
My name is Kevin Malone. I'm attorney at law representing Southside Tattoos, Tattoos on 9, and Al's Tattoos with regard to the above referenced ordinance. Now, it's our position based on the state law NJSA 26-1A9. Now, and I'll read it in pertinent part. This chapter shall govern all businesses that offer tattooing, permanent cosmetics, and ear and body piercing to the public. I'm going to move on down just to the bottom line, which says, under the authority of the above referenced statute, the provisions are enforceable by the New Jersey State Department of Health and Senior Services and local departments of health. Now, our challenge to this ordinance is based on the following. It's one of the most basic principles of American jurisprudence of doctrine of preemption, where the senior government, whether it be federal or state, has acted in such a manner as to legislate and regulate an industry, a body of law of any sort, that the lower governments cannot regulate in that nature. And that's exactly what this ordinance is. It's an attempt to regulate a matter, a body already spoken by for NJSA 26-1A, and therefore is illegal on its face as an attempt to usurp the authority of the state and local health board. Now, in reference to that, it says, under the law of authority and NJSA, the provisions are enforceable by the New Jersey State Department of Health and Senior Services and local departments of health. And that is defined in that statute as health authority. Means a registered environmental health specialist or health officer representing the New Jersey Department of Health and Senior Services or local health department. The Township of Howell is neither of those bodies and therefore has absolutely no legal right to regulate this area.
Do you want me to?
Yes, please.
I was going to ask, what do we have for our local health department? Isn't it the county?
Monmouth County Board of Health.
Therefore, based on the statute passed by the state, the county health department is the only legislative body that can regulate this industry. And in their failure to act in any manner, the Township of Howell cannot act in any manner.
Actually, we've enlisted the aid of the county board to enforce our regulations.
Well,
and actually, this,
Okay.
and it's.
Let go of the button, maybe.
Let go of the button, hold the button.
Which one?
It has to be
I don't
red.
think it's
It has to
picking
be
me
lit
up.
up.
It was red.
Okay. Speak a little louder so we can pick you up.
I believe that we've actually enlisted the County Board of Health to enforce our regulations. The regulation that you speak to is actually NJAC 8:27-1.1 at SEC, which actually addresses body art facilities, licensing requirements, the conditions in which they must operate under. And in fact, this ordinance itself actually came from the recommendation of our County Board of Health.
well, that may be true as far as a recommendation. I would like to see it. I would like to see it in writing, because under that, the logic that you're giving me, that would be a county-wide regulation, not just for the Township of Howell. Every municipality, township, city, borough, ever how defined within the County of Monmouth would also have to have a mirror of this ordinance, and it would come down from the county. It would not go up from the township.
Actually, that would only be the case if we had our a local Board of Health, which Howell Township
Exactly.
did have, but we've actually, I believe, is it an interlocal agreement? I'm not really sure how we did it. It predated me.
No, but ma'am, that gets key.
Okay.
How you did
Let her
it.
finish, please, though. Once you speak, and let her finish.
Okay,
Then
sure,
You can speak,
sure.
no problem.
I would certainly be happy to find out or provide for you the agreement that we have in place with the County Board of Health, but whatever regulations we have on our book, licensing requirements for whether it's kennels or
Watch that.
and I'm just using it by way of examples, food establishment licenses, what have you. The county board, our Board of Health officer comes in and does the inspections. The applications are filed here and then submitted to the Board of Health.
The applications for
Licenses.
are filed here,
No, you pick them up
right?
here.
Right.
We then forward them to the County Board of Health.
Right, they're available here, but the County Board of Health is the ultimate legislative body responsible for denying or granting these licenses.
And I believe the statutory section that you referred to allows municipalities to delegate that authority to a County Board of Health.
I don't see that.
I would be happy to
Please.
forward it to you.
I would like to see that very much, because under the statute I'm looking at, and I can provide it to you, I may have misquoted it, it is 827-11-5. There's no indication whatsoever of any authority being granted to any local municipalities. That any regulations that were to come regarding this, the only body designated by the state of New Jersey is the local Department of Health, which is the Monmouth County Department of Health. Then it has to be a blanket rule throughout the county for every tattoo shop in every town, in every borough, in every municipality, be the same. There can't be just for Howell, just for Freehold, et cetera, et cetera.
Sir, if I might just clarify this for you. Other
Please.
municipalities can have licensing requirements on in their ordinances.
I need to see the basis for that, miss. I don't mean to interrupt, but I mean, you keep telling me this. I need to see the basis of it. I need to see it in writing. I need to see the written agreement between the county and the township, or the state and the county. I need to see this in writing. And not that I don't take your word for it. This is my area of practicing law, statutory interpretation, preemption, supremacy, all of this. And in order for me to take the word of any legislative body, I need to see it.
I'd be happy to forward it
Thank
to you,
you.
whether it's an interlocal agreement or a statute.
And I will
that
I'll
actually-
make a opinion once I have a chance to see that. All right? Thank you.
Thank you. Anybody else? Would anybody else like to speak?
Ladies and gentlemen, my name is Troy Chartier.
Please sit down, name and
Thank you,
address,
sir.
please.
2958 Route 9 South. I'm one of the owners.
Okay.
As I look at this town council, I've never seen one individual here ever step into my establishment. You know, I find it odd that a township who prides itself in whatever we're priding ourselves in here has never once even bothered to stop in to say, hey, what do you guys do? We're going to legislate you. We're going to charge you a fee. We're looking at public safety like you stated to Channel 12 News. You certainly categorize us under sexually oriented businesses, which
Please speak into the mic, sir.
which in no way, shape, or form are we a sexually oriented. But I find that offensive. You know, you stated in the past, the township has stated in the past that we were slimy and what was it, seedy or shady businessmen about 8 years ago.
Excuse me, but none of us right here were here 8 years ago.
Understandable. But the problem is, it depends on who's here this week. Depends on the legislation governing what I do for a living. You know, so we get new people in, and next year somebody else has a different opinion, and let's see, how do we pay our mortgage, pay for our kid in college? Well, we changed our minds. We don't like you. We do like you. This is out of control. This is absolutely out of control. We're not a sexually oriented business. I have no affiliations with an outlaw motorcycle gang. We don't sell drugs. You know what I do? I support local charities like Elks Club for special needs children. Your very own Howell First Aid Rescue, we support organizations like that. Ronald McDonald House is a big organization we donate to. The fee of $1,000, that's abusive. I really don't see where that number came out of. The amount, and what determined the amount of insurance that we needed? What was that based on?
Actually, that was actually a discussion I had with our County Board of Health. She reviewed the surrounding towns and what their insurance requirements were, and most of them were $1 million.
Okay.
Very few were $500,000.
Oh.
And actually, the state doesn't put a limit on it. It just simply says that you're required to have it.
I understand that.
And in order for us to enforce these regulations, and in order to make sure that what you're doing, and I'm not saying that you're not doing it properly or within those guidelines, if we don't have it on our books and something goes wrong, then she has no power to revoke your license.
She being whom?
The County Board of Health officer.
Well, I talked to Tim Smith, who's in charge of this in Trenton. He's the official
Into
who...
the mic, please, sir.
I talked to Tim Smith, who's actually in charge of this entire human services and health department in Trenton, who succeeded Tony Monaco, who is the author of 827. And he thought that there is no way possible that this township could have the authority to supersede the state. If you want, I can give you his number, and we could certainly talk to him. Yeah, that's one of the phone calls I made. I've also made calls to Chris Smith, my congressman. I've talked to John Corzine, and I also talked to a representative from ACLU. If this goes through, I mean, we're going to be seeking legal action against this township. Make no mistake about it. Absolutely.
Hold on. Hold on, sir.
Yes.
If somebody else would like to speak on this orders, they need to speak before you.
Thank you.
Good evening, everybody. Richard Perrone, 399 Route 9 Howell, the owner of Studio 9 Tattoos for 10 years. I'm just here to say that this ordinance, and I saw Ms. Dalton mouthing that the fee should be more than $1,000. A shop just opened up. Excuse me. I'm speaking.
No, if you want to know what I mouthed, I said I was with him.
Okay, I apologize
Okay.
then. I thought you were mouthing it should be
No.
more. A shop just opened up in Freehold a month ago. The fee was $225 for a license. What is the difference between Freehold Township and Howell? That I should pay $1,000 for a license? Okay, it is abusive, Robert, Mr. Mayor. Okay, and all of these ordinances that are on here are just... I don't know who they were written by. To me, they look like they were written by somebody from the health department, you know, with no knowledge of the laws. And if it does go through, I'm here to say that we will push forward and take this to a higher level. It's a First Amendment right, what we do.
No problem.
Okay, thank you.
Would anybody else like to speak on this ordinance? Sir, come on back.
Thank you.
Where the owner has to be present.
Hold on. All right, there is really quite another simple answer to this. This is going to be a controversial issue. It's not going to go away. The name that I haven't heard mentioned here, or the title I haven't heard mentioned here, is the Attorney General of the State of New Jersey, not brought into this. The Attorney General is the top lawyer in the state of New Jersey and will grant an advisory opinion. So we're currently drafting a letter with exhibits to request a written advisory opinion from the Attorney General of the State of New Jersey. And once that, assuming that she does grant that advisory opinion, you could either join with us in requesting an advisory opinion, save us a lot of trouble, or just we will do it on our own without further and get an opinion from the state.
Anybody else from the public? With that, I'd like to close the public portion of the meeting. Anybody from the council like to speak about this ordinance? I would like to ask just one question. I'm hearing it implied that no other town in the state of New Jersey has an ordinance. Is that true?
Absolutely not.
Okay. So, all right, just...
Well, I'm
Sorry, the public portion's over. I just wanted to ask a question to answer something that was on my mind that I was hearing. That's all. Okay. I'd like,
Mr. Mayor,
yes, Deputy
I
Mayor.
have some concerns. I don't agree respectfully with council that we don't have the right as the township to hire the Monmouth County Board of Health to handle our health enforcement. We abolished the Board of Health, the local Board of Health, as a more efficient manner of dealing with health issues, and we adopted an ordinance pursuant to NJSA 26:3A2-1, where we were able to have that interlocal agreement with the County Board of Health. We regulate health issues all the time and delegate the enforcement of those to the County Board of Health. I see the need for some regulation, but I am also concerned that I do agree with the sentiment of the comments that have been made about the fee being significant. And I'd like to know, compared to other similar businesses, what we charge. I know our junkyard ordinance, we charge $500. I know that we're on for increasing that this evening, but it's only going up to $650. I don't know what we charge for a cosmetology mercantile license, or if we even have one. I don't know. I understand. I asked a question. My first thing that popped into my head is, if we're worrying about health and safety, are we regulating tanning salons? Are we requiring them to have insurance of this type, and are we requiring them to pay a fee every year for a license? And I learned that we don't have that, but that one's in the works. I'm not one for over-regulation. And I'm not anti-tattoo, trust me. But I think that I am really not comfortable with the $1,000 fee for a local business. I appreciate you coming up here and telling us what charitable endeavors you have. That's very appreciated. And the reason I haven't stopped in to see is I don't have a need for your service these days. All right?
Can I ask you a question also to explain
No,
that's on there?
please. It has to go in the public portion. Now the governing body has its time to ask its question and discuss. I'm sorry. Can I reopen this back up to the public? No, was the answer. Okay, God bless. I'm sorry. Anybody else?
I would just like to indicate exactly what Deputy Mayor said. I think she brings up some excellent points. I'm a business owner. I know that's a lot of money, and I know in this tough Economic times when you have to come up with $1,000, that's a very difficult thing to do, and a drain on any business. I don't care what kind of business it is. There was never an intent to target. There was never a thought that there was some type of issue behind this, other than we were doing what we thought, I think, in alliance with the Board of Health to try to have some regulations in place. The only issue I have is really the dollar figure. With $1,000 is a lot of money, and that would be my question, I guess, for council. If there's any, do you know the range and maybe the?
The range is anywhere from $250 to $2,000.
Okay.
Excuse me?
The application fee, their licensing fees range from $250 to $2,000.
Who's that?
I'm sorry?
Other towns, looking at other towns, my question was, what do other towns have in terms of fee? And I guess we've heard that Freehold Township, at least it's been brought up, is about $250, but you're telling us in terms of the range of towns, there's some upwards of $2,000 for that.
That's correct. And the fee for the license is actually up to the governing body, just so
Okay.
you know.
Okay.
Mr. Mayor, if I may?
Councilman Memble, yes.
The ordinance, we do need some type of regulation to have in the town for the tattoo parlors. We must have something on the books. And I think that the attorney did a wonderful job on writing and creating the ordinance. But I do believe, I do coincide with everybody else as far as maybe the fee might be a little extreme. And maybe we should bring this back for further thought for another time on the discussion of the fees.
Whatever it is. Remember, council, to make a motion?
Mayor, I just have, I gotta ask the question. Where was the question on the cost of the fees when this was introduced? Why were none of these questions asked then? The number, the $1,000 number was, I'm sure, was in the ordinance and the backup when it was introduced, correct?
Yes.
Did we introduce this at the public meeting over at Aldridge School?
No.
Was before that?
Actually workshopped it and then introduced it.
Well, I recall when we workshopped it, it was presented as, this is what the Board of Health is recommending. We don't have anything on the books to regulate tattoo parlors. Should we consider introducing something? And the general consensus was, yes, we should.
That's correct.
We introduced on March 3rd.
Mr. Mayor?
Yes, Councilman.
I mean, when we bring these ordinances up to pass them and we read them, I mean, we have the public portion. This is the only time that the public and the owners and shop owners can come out and the taxpayers can actually come out against anything that may be opposite of what the council may be in favor of doing at the moment. We all agreed that we needed something in place. We asked the attorney to put something up there. She did a wonderful job. We were all in favor of the fee because we had no fee. And now we're just finding out that we have a little more history of what was going on around Howell Township as far as the other shops were concerned. And that's all I have to say.
Can I ask, whenever we introduce an ordinance, I think we tell the public, oh no, you can't speak about it tonight. Come back when we have the public hearing next week.
That's correct.
Can we have, I mean, look, okay,
Well, they
we
can
need
speak
to either
during-
have it when we introduce.
No. The only thing is that on regular public session, obviously, they could speak on the matter. I'm not certain on this one, but normally we have it on for discussion, then we have it on for introduction, and then this is actually the third time that we see it.
So the other two times when it was discussed, the fee was discussed as well because it was in the backup, correct?
On the introduction, I'm not sure when we did the discussion that we had that.
I don't think it was in the discussion.
No, I agree
about
with
the
you.
fee.
I agree with the deputy mayor. Only upon introduction.
Well, I think this is exactly why we want the public to come out. I mean, I certainly know that we're, we're trying to do the best here and trying to be efficient as possible, but I think you've seen recently that when we've had the public come out and give their opinion on it, it matters to us, and it certainly has an impact on how we look at things. We certainly are concerned about not only the public, but also how it affects the businesses. So I think it's a positive thing if at least we're hearing from people and seeing how it impacts them.
Mr. Schlegel, do you have a ballpark number that you could give me? How often the County Board of Health on our behalf does inspections and what it costs us each time they walk in there?
I'm sorry, I really couldn't even give you a ballpark on that.
Once a year.
Okay.
Oh, no, I think he meant how many times you do any kind of inspections on all of the...
Correct.
Right, no, I don't have that.
Mr. Mayor, I'd like to move that ordinance number 0-09-11 be tabled.
Do I have a second?
I second.
Table to when?
Table to when?
Or pulled from the agenda, what is the real
You
motion?
table it, if you're tabling it, you're leaving the fee number in place.
Okay.
You
All right, then
have to vote for it to be knocked down.
I would,
Same fee.
well, I would, if I move to amend it, no, I don't even want to do that, because I'd like to,
It's also substantive change.
it's a substantive change.
So you can vote it down.
Yeah, then I'd like to move that it be denied,
And I would
voted
second.
down.
Can I have a roll call, please? A yes is to deny it.
We need a second first.
I second.
You second,
Yes.
all right.
I second.
A
Yeah, the yes would deny.
a yes vote is
Would
to
to vote
deny
down.
the ordinance.
Mrs. Clark?
Yes.
Mrs. Dalton?
Yes.
Mr. Howell?
No.
Mr. Memolo?
Yes.
Mayor Walsh?
Yes. Okay, that's it on that one.
Wait,
Please.
excuse me, Mayor, is there further direction on this, or?
Ask the Deputy Mayor, Councilwoman Clark on this one, please. Okay?
Do you want to have it on for discussion again?
Me personally, absolutely.
What,
Okay.
what I would like to see, since we are talking about, I'd like to see it not necessarily as, well, business specific with regard to, I know the health issues of the floor cleaning, the wall issues. I read through the ordinance, and those parts, I guess you can't really lump those in with a tanning salon. I really think that the licensing fees should probably be in a different place. I know, I hate to create more work, but
It actually is in a different place. It's on, the fee ordinance is up for introduction, and that fee would have been in a different location. But it's under its own heading, body art facility licensing fee.
But I would like to see us look at the fee, lowering it. I think $1,000 is much too high. And I'd also like to know what the other towns have as insurance requirements. I'd like to see what the minimums are in locally.
We can provide that.
Believe you have your direction. Anything else?
No.
Okay.
Sir, can I ask you a question?
No, sir. We're done.
Thank you.
We're done with that one. I would answer you, God bless you.
I just wondered if we were going to be notified if, on the next one.
No special notice. You gotta.
Okay?
Just for the record, the agendas are posted on the website, the Friday before each meeting.
There is a problem with the website. When you go on there, you try to download what the agenda is, it comes out encrypted. And I can show you on my computer if you ever want to stop into my tattoo studio.
I think I will.
On Route 9?
Thank you.
Thank you, guys.
Thank you very much. Okay. 884. An ordinance to amend the capital ordinance with the ordinance corrects the ordinance for the Route 9 sewer extension by correcting the number of years that the property will have to pay the assessment from 10 to 20. Ordinance number 0-09-9, introduced and passed the first reading on 3/3/09 and published. Recording law is now being taken up for further consideration and public hearing. Affidavit of publication of this ordinance in the Asbury Park Press issue of 3/6/09 is submitted and is noted that a copy of the ordinance had been posted on the bulletin board in the municipal building and copies were available to the general public upon request. Ms. Woolman, please read the title of the ordinance.
Bond ordinance amending in part bond ordinance number 2003-25, adopted on July 21, 2003, as amended by bond ordinance number 2004-01, adopted on March 16, 2004, as amended by bond ordinance number 2005-16, adopted on April 5, 2005, providing for sewer collection system improvements and directing special assessment of cost thereof in order to extend the number of annual installments within which the special assessments are to be paid to 20 pursuant to NJSA 40:56-35, authorized in and by the Township of Howell in the County of Monmouth, New Jersey.
Mr. Mayor, I'd like to make a motion.
Oh, I got to open it to the public first.
Sorry.
I'd like to open the meeting to the public, please. Could you please hold the conversations down? Please, sir, could you hold the conversations down in the back? Appreciate it, thank you. I'd like to open the meeting to the public. Anybody from the public like to speak about this ordinance? Mrs. Smith? Seeing if you're awake, dear.
Oh, I'm awake, my eyes hurt.
So do mine, ma'am. I'd like to close the public portion of the meeting. Anybody for the council?
Mr. Mayor, I'd like to make a motion on this ordinance. Motion that ordinance number 0-09-9 be finally passed and adopted at the notice of its passage and adoption be published in the 3/27/09 issue of the Asbury Park Press by reference to its title only.
Do I have a second?
I'll second that.
Have a roll call, please, Ms. Woolman.
Mrs. Clark?
Yes.
Mrs. Dalton?
Yes.
Mr. Howell?
Yes.
Mr. Memolo?
Yes.
Mayor Walsh?
Yes. Okay, we're gonna go to, I'd like to take a break for 5 minutes, and then we'll go directly to 882. We'll do the introductions after. So, okay. I'd like to reconvene the meeting. Would you please close that door back there? Everybody, just ask you to be respectful, okay? 882, land use to rezone certain lands into the planned mixed-use district, AST settlement agreement. Ordinance number 0-09-10, introduced and passed on first reading on 3/3/09 and published according to law, is now being taken up for further consideration and public hearing. Affidavit of publication of this ordinance in the Asbury Park Press issue of 3/6/09 is submitted and is noted that a copy of the ordinance has been posted on the bulletin board in the municipal building, and the copies are available to the general public upon request. Ms. Woolman, will you please read the title of the ordinance?
An ordinance of the Township of Howell, County of Monmouth, amending Chapter 188 Land Use Ordinance to rezone certain lands into the planned mixed-use district.
At this time, I'd like to open the meeting to the public. First speaker on this will be Edward Liston. Please state your name and address, please.
My name is Edward Liston. I'm an attorney at law of the state of New Jersey with offices in Toms River, New Jersey, and I represent Greg Fox and Al Hurley, both of whom live in the area which will be directly affected by the proposed rezoning in this ordinance. At the outset, Mr. Mayor, let me say that it saddens me to be here tonight and to be as critical as I have to be to you and to Deputy Mayor Dalton, because I know you both personally, and I know you both to be dedicated public servants and people of honor. But when you set about to make a mistake as big as this mistake is going to be, and as much damage as it is going to do to this town, I have to say what I feel not only as a lawyer, but as somebody who has been involved in the land use process for my whole legal career. This ordinance is inconsistent with the Howell Township Master Plan. It constitutes contract zoning, which have been declared illegal by our courts. It overburdens the infrastructure along White Street, which is already in disrepair. You talked about it yourselves this evening. There are well and septic problems in that neighborhood. And in all likelihood, the developer of this tract will want or be required to put an access onto White Street for ingress and egress. Frankly, as somebody who represents 2 planning boards and a board of adjustment in Ocean County, I can tell you that safety requires that so dense a development have a second access, not only an access onto Route 9, but an access somewhere else, and the only access they'll have is White Street. In addition, DOT is probably going to require that as a condition of an access permit to Route 9. So what you're doing is taking a rather pristine, bucolic farm neighborhood and turning it into what has the makings of an urban disaster. Much of this area is environmentally sensitive and is located in the Matitaconk watershed. We heard about that earlier tonight. This is the sort of dense development that anybody who is familiar with that watershed and how hard people have been working, not only in this town but in other towns, in Manasquan, in Brielle, in Bricktown, to preserve it, they'll tell you that this kind of dense upstream development will further endanger and degrade the watershed. From a planning standpoint, this rezoning threatens to start a dense development domino effect in the area. The Pinnacle property in Block 130 is directly across White Street from this property. This thoughtless, ill-advised rezoning gives that property owner a strong argument for rezoning from the ARE2 zone to PMU or some other more dense zone, which threatens this entire area of Howell Township with a blitzkrieg of high-density development. The amended settlement agreement represents, in my view, a total capitulation on the part of the mayor and this council to the bullying tactics of AST Sunnyside, aided and abetted by COA. You know, you can sit here and pass all the resolutions you want talking about COA being wrong and COA not doing the right thing by Howell Township or other municipalities, but unless people like you start standing up to them and telling them, we're not playing your game, you can't threaten us and you can't bully us, and neither can the developers that have you in their pocket. That's when things are going to change. Yeah, a constitutional amendment is probably going to be necessary, or a different Supreme Court may be necessary to undo COA. But I can tell you from the towns that I represent as a planning board attorney that we fight as hard as we can not to have things like this happen to us, and not to sign on to deals that are going to do as much damage as this deal is going to do. By signing the amended settlement agreement, you handed this entire neighborhood over to AST to be crucified on a Mount Laurel cross simply to appease COA and allow AST to reap windfall profits. You know, in reading this settlement agreement, I was reminded of Neville Chamberlain, and also in reading some of the recent newspaper articles where the mayor's quoted about, well, we had to do this because if we didn't, we'd just have an onslaught of builder lawsuits. I was reminded of Neville Chamberlain getting off the plane in London from signing an appeasement agreement and saying, peace in our time. It didn't happen then, and it won't happen now. This is beyond appeasement. This is unconditional surrender to forces that do not have the best interest of this town and its character and its quality of life in mind. The forces that you have surrendered to just want to put money in their pockets and could care less about your quality of life, particularly in an environmentally sensitive, traditional farming area like this neighborhood. But what is most upsetting to me is the way that you sold out the citizens and taxpayers of this neighborhood by amending a settlement agreement that they all had input into behind their backs. When the settlement agreement, when the first settlement agreement was entered into, there was a lot of input from my clients and others in that neighborhood. And they weren't pleased with it, but they felt that they'd gotten a fair shake, and it was the best that they could do, and the best that the town could do for them. And then the town, without notice to them, Mr. Mayor, you and the council, and all those lawyers in that smoky, dark room in Trenton that you talked about, sold them out. Even though you knew that they had an interest and you'd consulted with them on the earlier settlement agreement, you didn't bother to consult them on this one. That kind of action is disingenuous at best and deceitful at worst. You have betrayed the trust that this neighborhood put in you. You sold them out. You have left these citizens with no alternative but to fight their own government, the government that should be standing up for them, in court, and fight they will. Whatever happened to the spirit of the patriots, some of whom lived in Howell Township at the time of the Revolution, who fought unfair taxes from the British, who dumped tea in Boston Harbor to show them that they weren't going to give in to what they felt was a gross injustice? I believe that everybody on this dais believes that the COA pogrom, if you will, is a gross injustice. But nobody wants to stand up to it. You just want to cave in, let the developers and COA have their way. I hesitate to use this word, but I can't think of another word that's kinder. I think that is shameful. And I think the way this amended settlement agreement was handled was shameful. And regardless of the outcome of the litigation, your betrayal of your constituents, the neighbors in this area of your township, will never be forgotten. I urge you to change course, to stand up for the forces that would ruin this town. Vote this ordinance down. Tell the developer and COA, you changed your mind, you're not going forward with this agreement, and fight them in court if you have to. Because otherwise, the citizens that I represent are going to have to fight you in court. Thank you.
All right, let's keep it down. Thank you, Mr. Liston. Let's keep it down. Next on the list is Lester Schwartzman.
My name is Lester Schwartzman, 3 Sunnyside Road. I have one question I'd like to ask. How did such organization as this developer or the previous owners, no, just the developer, received an agricultural deferment and pay so little money for taxes? It is not an agricultural land. It hasn't been an agricultural land for 15 years. I know the farm personally. They had chicken they gave up a long time ago. They were an egg-selling organization. That is not agricultural. How do they pay so little money for taxation when we pay so much for our properties that we live in? Can you give an answer for this? Somebody must have an answer. How does somebody get cheated out of this type of money like we are, and we're paying for them?
I don't know what they pay the taxes personally.
Well, I think it's time to find out then. Do you people know what they pay in taxes as agricultural land?
Let's keep it down, please, everybody. Okay?
I don't know what that property is taxed, that is, what the property is assessed at. I'm sure, I'd be happy to find out.
Is it assessed as agricultural?
We'll have to check that out and get that
You don't
information.
know?
No, there's 24,000 line items in Howell Township, and we really don't know each one, but I can certainly find it out and get that information to
Can you give that information back to the person ahead of me?
Absolutely.
The lawyer that was handling this, because he's directly involved with it. Because these people shouldn't get away with taxation.
He could
like
probably
this.
go right online and get that information.
Okay,
But I will certainly give it to him if he requests that.
thank you very much.
Thank you, sir. Next on the list about this was Esther Schwartzman?
Wasn't there someone ahead of me?
No, not about this. The person ahead of you spoke already about the Chamber, from the Chamber of Commerce about the sewers, ma'am.
My name is Esther Schwartzman, 3 Sunnyside Road, Howell. I have lived in this township for over 60 years, and I have seen it grow from farmland to some farmland left, very little, but the overbuilding of the area has created tremendous problems to the watershed, to the school systems, to the septic systems, to the flooding, to just about everything we touch on in the township. I have not been happy with the way things have been going in recent years. And this is just an example, and this one stands out because it is so abusive. We're opting for more units than the original agreement. The area was zoned because of watershed problems to ARE 2, 2 acres. Our area on our side of the highway, we're only 700 feet on the other side, was zoned to 2 acres from 1 acre for the same reason. That hasn't changed. It's still watershed. The density of this housing means that the majority of the land on that side and the affected property will be paved with roads. It will be concreted over. There will be housing. Where's the water going? It's not going to go into the wells. The land won't be able to absorb it. Is it going into sewers that you're going to have to build? Are you just going to build another big hole that will have to be treated for mosquitoes and will probably overflow? The increased traffic. Now, they built Sunnyside, that development right across the street from me several years ago, that tripled the traffic on the road at the very least, right? It has become very difficult to go in and out of my driveway. I can only imagine the impact at the light on Route 9 if an access is put in there like needs to be to handle that load. And if you divert it solely to White Street, well, then you're going to have to widen White Street to handle it, because it certainly isn't going to handle it now. It will bring in many, many children. We have just gone through a situation where you have moved to close a school, the Southern School, and I can agree with that because the school population has dropped. But this will bring in a whole new crop of children, and children are wonderful. I have my own grandchildren. Children are the best thing. They're a hope for the future. But it's going to impact the school system. And I think the way this was handled so quickly and with so little input and consideration from the public was not the best way to go. And I think that's about it. Thank you.
Thank you very much, ma'am. Anybody else? All right, we'll start with Ms. Abramo.
Grace Abramoff, 26 Glenmore Road. Sometime before the election, this was on the agenda, and it was pulled because of the fact that the advertisement and the resolution was written incorrectly. Am I right?
I believe that was Elon, not AST. That was Elon.
Elon?
Yes,
AR2 to AR6?
it was Elon.
Yeah,
The Elon
that's
property.
different
Different
project.
property.
Okay. Another travesty of our township. On this, what changed on this zoning from before? Why did it go from 118 homes that were age restricted, which was a halfway decent plan?
Excuse me. They were never, the initial settlement was not 118 age-restricted homes, ever.
It wasn't?
No, it was not, ever.
Mr. Mayor, I believe the language in the original MOU is age-targeted, which
Age-targeted, well,
means
55 and over,
Nope.
like?
age-restricted is 55 and over. Age-targeted means, yeah, okay, we'll try to, but we probably won't.
Okay.
Hold on. In the original settlement, it was 118 family units, 100 market rate and 18 affordables.
Well, maybe we have our attorney here that he could probably specifically answer that.
Would you like to come up?
I could have sworn, well, I'm not going to swear on anything, but I just want to, I thought,
I think Councilman Howell had it, the original agreement was, the language in that agreement was age targeted, and it was not age restricted.
And what's the difference?
I think the difference, the difference is that the way age restricted is by deed, they will be restricted as noted before to 55 and over. Age targeted, as I understand it, and I'm not a planner, but it's typically the way the units are designed. They're designed for not really to encourage children. That's at least how the developers pitch it. They market it that way, that it's sort of like for, I think for like people who have had their children are grown, and it's like a place to go to after their children are grown because it's based on the bedroom size and type.
it's legalese.
No, well, no, it's actually marketing-ese, not legalese.
Marketing.
Yeah.
Okay. Excuse me for the misinterpretation of the words.
Okay.
But basically, that's what I think most of the people thought that it was going to be, and that's why it was acceptable to that with the storefronts and apartments, that it was a livable situation. Then at 118 units for that piece of property was bearable. Now you're coming in with 220. Okay. Now before they were home owned, now they weren't owned before?
I don't believe so.
I believe that
These were never under ownership of the 118 before? They were under a rental agreement before?
Well, I don't believe they were constructed yet. They were approved.
Approved to be what? The 118, were they approved to be owned by the people who bought them?
Yes.
Owned.
They were.
Okay. So now...
Were they owned? Hold on. I would like to know that. Were they supposed to be 118 owned or rented?
I thought owned.
believe the change, Mayor, went from 118 age-targeted owned to the current arrangement is rentals. I believe it went from owned to rentals.
Right.
18 owned,
And,
220 rentals.
and I think that's a big, big difference. Years ago, I don't know who was here at that time. I know I was and fought it vehemently, and it's not there now. The property behind Wachovia Bank on Georgia Tavern Road was
Wachovia
planned on Georgia Tavern Road and Route 9, where Wachovia
Okay.
Bank is.
Mhm.
Years ago, there was a developer from Freewood Acres area that wanted to put in townhouses, rental units. I don't remember the number, but it was going to come down that it was going to be subsidized because it was going to have water and sewer, and it was predominantly going to be Section 8. Well, if you think this is going to be an uproar, that was really an uproar because of the fact that they were rental units and not home ownership. And now you're bringing this back 10, 15 years later, where you're bringing it from home ownership, where people take pride in what they have. They take care of their property. And not all, I hate to include everybody in everything. But for the most part, when you have a rental unit, it is not as well taken care of as a home unit. And what you bring into a rental unit of this volume is what you're going to have as you have across the street on North American Drive, with police calls, police calls, police calls, and police calls. It's wedged in between Freewood Acres, which has its own problems, and now you have that bridge that you had before with the egg farm, and then this little side of the street of Conover and White Street that bothered no one. Now to put that dense of a volume into that area, my math is not that great, but I figured it's somewhere in the neighborhood of 30 people an acre. That's a lot of people of different backgrounds, and we have a hard enough time in one room getting along with one another. But when you put people of different cultures and backgrounds and economical resources in such a confined area, one on top of the other, you're going to have a lot of difficulty over there. And the main fact I think that people are most objectionable to, that this changed. Where did it change? How did it happen that it changed from this 118 owned to this 220 rental?
Sure, thank you, Mayor. As I think this was discussed when the ordinance was introduced, this is sort of a long answer to a short question. I'm sorry. I'm saying this is a long, I'm going to try to keep it short, but as everyone probably knows who follows anything going on with state law over the last couple of years, COA last year adopted its new third-round methodology. It became effective in June. The regulation said all towns had to have a plan in by December 31st. The methodology was adopted like June 2nd. The regulations were amended twice between June and November, and the state was still requiring towns to have their affordable housing plans come into COA by December 31. If everyone may remember the newspapers, there was a strong current in the legislature and from the governor at the time to extend the deadline, and all the towns, including this town, were asking for that. Ultimately, the legislature and the governor did nothing, and all towns, including Howell, were required to submit their plan by the end of the year. When these regulations were adopted last year, there was a committee formed of council members, planning board members, and professionals, where various proposals which had been submitted to the township for consideration were evaluated, and ultimately a plan based upon the consensus of that committee last year was put together and presented to the planning board last December 1st. People earlier and now have spoken of the rush. The rush was really the state-imposed deadline of December 31st, which is why all of this occurred in Howell and like in many other communities in the month of December of last year. So there was proposals made to a committee of planning board members, township committee members, and the professionals who guide both boards. And eventually, and this property and other properties were ultimately included in the township's affordable housing plan. In terms of the question as to why rentals, it's actually, I don't know if everybody knows this, but the Howell Township's third round affordable housing obligation is determined by COA was roughly 750 units, something to that effect.
More than that, 900.
864, and it was 864.
So elaborate on that.
Yeah. So what the tension that was going on last year, and this goes on in every suburban community, understandably, is you can meet that through, first of all, there's a rental requirement under COA's regulations. 25% of your plan needs to be rentals. Secondly, to the extent you exceed that rental minimum, the township gets a 2-for-1 credit for every rental above the 25% minimum, between 25% and 50%. So the effort that was made here at Howell last year, which was a direction from this council, the council, was that you wanted to limit overall growth and development in the town, because if you just met the rental minimum requirement, you would have significantly more units you would have to place either in this development or elsewhere as owned units. So the tension was rentals versus ownership, and ultimately the policy decision was made that you wanted to limit the impact on schools by limiting the total number of overall units, which was accomplished through rentals as opposed to owned. And the other owned units, and the other point I'd like to make is that in the case of this particular development, I believe the developer is actually going to be managing the units, which is also something which is attractive to many towns, because you have the owner of the property who's going to be responsible to maintain it, and they're not going to be having a third party do it. They're going to be doing it themselves. So that also is attractive, because you have the owner of the property who's actually going to have an investment to ensure that the units are well maintained and there's order within the community.
I understand what you're saying about the 2-to-1 credit. That's more the impetus of this change than anything. But I question the fact that whether an owner being a manager has any effect on anything, because most landlords are slum landlords, and they could care less. And then they'll flip that property and turn it over, as we see what happened on Route 33 with the retirement village. It started out with one developer and wound up with another developer. 220 units will promote more children, not less children, in a home ownership, because there's more responsibility in a home that has a family and obligations to meet as far as mortgage and taxes, opposed to rent. You can be a vagrant and not have to pay rent for months before somebody is thrown out. I personally know someone who didn't pay their rent for 10 months, and there was no hardship for them except for the fact that they were evicted. Rental units are not the way to go to preserve the lifestyle of Howell Township. At one time, there was an ordinance on the books of Howell that there were no rental units allowed, period. None. Zippo. You couldn't even have a rental unit in this town. So see how we've changed, how we've gotten away from home rule here. And I think it's very important that we keep in mind the residents of Howell. We want a stable population, not a transient population that are here today and gone tomorrow. And what they do with those units, you'll never know. And going back to the Section 8, there's nothing against those landlords in taking in Section 8 people. I'm not against Section 8 people, but again, it falls upon the taxpayers of this town and this state to be subsidizing everybody. I mean, our country is bailing out everyone, except for the hard-working people who pay their taxes, whether it be state, local, federal, or property taxes. Please think of us first. This should have never been agreed to, 220 rentals. Go back to the 118 owned units. Thank you.
Hold on.
Mayor, if I could real quick, I just went through the original MOU from 2006, or the original agreement, and nowhere in there does it say that these are going to be family-owned units. It just says units. So there was...
Great. Hold on, Ms. Abramov, if you want to speak, please.
So just
Please.
because people think that they're going to be owned, if it's not written down, and I learned this from Mrs. Smith, sitting at a planning board meeting, If it's not written down and it's not there when the paperwork's signed, it doesn't mean anything.
I agree with you. I learned that a
Okay.
long time working in doctor's offices. If it wasn't written, it didn't happen. And
See,
that's
I-
a very strong statement. But what was perceived by, I think, most of the people in this town is that they were going to be home-owned. And I don't know where that perception came from.
I don't know.
You weren't here, I don't think.
No,
Maybe
but
you
I
were.
remember it coming to the planning board, but, you know, it's like you said, they perceived that they were gonna be owned, but
Owned.
according to the according to the agreement.
Now,
they were
which
just
agreement is that
118
dated?
From 2006. They were just 118 units. And getting back to Mr. Bayer's point about what they considered age-targeted units, in the agreement from 2006, age-targeted units were 3-bedroom units.
That's not good.
Okay, just so you know, I always thought they were rental. That's why when somebody mentioned 118 owned, I always thought they were rentals, okay? Because that's what was discussed. But I'm not saying owned wasn't discussed also, but I always thought the agreement was 118 rentals. And I just wanted to be clear about that I was always under the impression there were 118 rentals. And also, am I correct, Mr. Bear, that we have a minimum of 215 of these affordables that must be rentals?
212, Mayor.
212 must be rentals.
But do they have to be there? You have Route 33.
With no sewer.
Okay.
That's not my
let's
problem,
let's
whether
not
they
go
have
there.
sewer or not. They should be sewers
okay.
there. But I'm just saying, you have Route 33.
Okay. Okay.
You have Route 33 that has nothing on it, that I wish to God somebody would go and do something with Route 33 and develop that for your rental unions, because you have a bus line that also runs down Route 33 between Asbury and Freehold. But I just want to get back to that perception of it being owned. I mean, I'd like to know, I used to speak to the mayor before here, and that was the impression that I think most of us got. Am I wrong? I don't know.
I always thought there's supposed to be
Am I
rentals.
right
I'm
or
not.
am I wrong?
Okay, hold on.
now,
Hold
Where
on.
is that
It's
coming
okay.
from?
Yeah, I don't.
Well, I could tell you, I could tell you that, now, as the point Mr. Howell made is in the agreement that we drafted, we actually put the word rental in, because I wasn't here when the first agreement was done, and I would agree with you that the language in the agreement doesn't say that, but I will tell you that when the developer's attorney talked to me and we were negotiating the language in the agreement, the representation to me was that they were being changed from owned to rental.
Thank you very much.
That's where my perception is
Okay,
from.
but I'm telling you that I always was under the impression.
See how you can hear different things from different mouths?
I don't.
And you know that old game you used to play about the telephone? You tell the story here and then you wind up over there, it's different. I thank you very much for that statement, because that's the honest statement, that most of the people in this town and in this room thought they were going to be owned. And I think that's the greatest upset, to see bad enough you're going from 118, and I realize it's only a plan. I do know that, the difference between, we have to wait before it comes before the board. But you're going to open up a can of worms with this if you change that, even if it's a perception, to go back to the perception of it being owned. And one other thing before I leave, why all the exceptions to this plan? Why is it that all these exceptions were put in, that they're not obligated to do this, to do that? I mean, there you're giving the town away. And I'll leave that for somebody else to speak. I don't want to take their time. But please go back to the original agreement of being homed and not rentals. You're opening up a big, big can of worms. Thank you very much.
Mayor, if I could just touch on what
Okay,
Mr.
come on, folks.
What Mr. Davidmoff said, and I've heard other people say that, you know, we're not making them do this, we're not making them do that. That was also all in the original agreement. And I think I asked a question, and I have the original agreement here, and I asked a question of Mr. Bear at the last meeting when he was here. we're not allowed to place those restrictions on COA developments. We're not allowed to tell them to replace the tree. We're not allowed to, we're supposed to make them as affordable, or, is that the
Yeah,
right, as
Mike,
affordable,
the language in the COA regulations say that towns shall not impose cost-generating features, and tree replacement is an example of that kind of thing.
All right, so a lot of these things that I've heard of, well, you know, we have to join litigation with them. Those were all things that were in the agreement that was originally started, I would imagine, back in 2004. So even if the number never changed from 118 to 220, all of those other things were already there when the last agreement was signed December 20th of 2006. The developer not needing to do road improvements, the town having to co-join in litigation if somebody challenged this. All of those things were there in 2006.
Well, like everything
They're not
else,
new.
When it comes down to the wire, is when you hear the most objections.
Deputy Mayor?
I want to take off on what Councilman Howell said. The number of bedrooms, can you clarify for me, Mr. Bayer, under the original settlement agreement at 118, it was 3 bedrooms, right?
The agreement,
3 bedrooms per unit, that is.
it says age-targeted units shall mean townhouse units up to three bedrooms.
Okay.
And recreational amenities.
Okay. So what's that, 356, 354 bedrooms. And now it's 2-bedroom units. Am I right about that, or is that inaccurate?
If I could.
Well, yes, we'll hear from our planner.
Please.
Jennifer Beam, I'm the COA planner. All of the market rate units are going to be 2 bedrooms. But the affordable units, which is the 60 affordable apartments that are on site, COA has a regulation that would preclude all of them from being 2 bedrooms. 20% have to be 3 bedrooms, 20% can be 1 bedrooms, and the balance 2 bedrooms. So they're going to meet COA's regulation for the bedroom distribution for those 60 units, but the balance of the units on site, 160 market rate units, will be 2 bedroom. So the overall bedroom count, and I'm sorry, I apologize, I don't have the actual number here, but the overall bedroom count for the project goes down.
If 20% can be 1 bedroom and 20% can be 3 bedroom, the two of those, you average them together, you wind up with 40% 2 bedroom and 60% 2 bedroom. So it sounds to me like it's 2 now times 220, so 440 bedrooms. Am I right? No?
Yes. Yes, 420 units with an average of 2 bedrooms each. Some are 1 bedroom, some are 3 bedroom. 440 is the number.
So it's more bedrooms.
It's more bedrooms than it would have been before when it was 118. Okay, there would have been some 3 bedrooms in there.
354.
It was 354. So it went down just, it went from 354 to 440. It went to a difference of 86 more bedrooms. Okay? It did go up, 86 more bedrooms. Okay?
For 86 more bedrooms for 102 more units.
And
No, that's the maximum.
All right, shh. All right, let's try to keep it so that that is the minimum. That is correct. That is correct answer. Okay? The one thing I really hope for everybody is that let's get the accurate information. I mean, I think a lot of misinformation's being set out there. Okay? And I believe it also went from, the proposed plan went from 3 floors to 2 floors.
that's correct, Mayor.
That is correct, okay? And I want to be clear about something, because it's something that's bothered me from the beginning also, and not about this project or any other project. That we are mandated by COA unless we had taken the the tack to just fight them in court and fight every builder under the sun. Okay, that if we lose, we opened up the town. And with COA, we were mandated to do affordable rentals, affordable market rate, and affordable seniors. Correct?
Well, affordable for sale, Mayor. Not
For sale.
Not, yes.
Hmm? For sale, rentals, and senior, a mixture. So there was no getting away from doing affordable rentals. Somewhere along the line, in Howell Township, affordable rentals were going to have to be built. Okay? So,
Mr. Mayor, I have 2 questions for Mr.
All right.
Bayer.
Mayor, can I just say one other thing? I'm
Go
sorry.
ahead.
I just want the record to be clear, which is, when I spoke to the planner before on this on the issue raised by Councilman Howell,
Mr. Smith, if you could, please, dear.
The prior agreement was silent, as it did not say for sale or rental. The agreement we prepared was specific and said rental. So it was my recollection that because of that difference, that the prior arrangement was owned units, but the planner was advising me that, in fact, under the old agreement, as the mayor pointed out, rentals were in fact contemplated. So I want everyone, I'm not, again, my memory was just from because I put the word rental into the agreement, so I thought it was a change. But it was actually just a clarification to make sure we all knew what we were talking about.
And if I might, to further clarify a couple of issues. Number one, I've just been corrected, and some of the market rate units will be 1-bedrooms. A total number has not been provided to me, but there will be no 3-bedrooms in the market rate unit. So I think when I represented that it's a reduction in bedrooms, I misspoke, and I think it's more of a reduction in bedrooms per acre than what was proposed in the previous settlement. And then I just need to further clarify one issue in that, and I'm sure it's going to come up, which is why I want to clarify it, is that when we had done our original plan and we had presented it to the planning board, this issue of age-restricted versus age-targeted had come up because some documentation that we had when we prepared the plan had identified it as age-restricted. We clarified it, and so that's what the plan shows. We clarified it at the planning board meeting at the time. There were some comments from members of the planning board as well as members of the public that clarified the situation. So we have an itemized list of those types of things, which will be reconciled when we make our submission back to COA, after they send us the letter identifying those issues. So I just wanted to clarify that up front because I'm sure that will come up. That was an issue that was addressed and raised at the planning board meeting. We're aware of it. But that was really dealing with the old settlement agreement, not the new. The new is identified in there as non-age restricted rentals. So I just wanted to clarify that before it became an issue later.
I have 2 questions for Mr. Bayer.
Okay, go ahead, Deputy Mayor.
Mr. Bayer, there was a comment regarding Howell Township prior to this, and Ms. Kingdon maybe as well, having had an ordinance that said that rentals were prohibited en masse throughout the town. Is that kind of an ordinance legal or enforceable?
No.
Okay.
Okay.
It may have been then, but it's certainly
There's
not
a real
now.
good chance that 30 years ago, it was perfectly legal. The same as some other things we know that are very detrimental to our health were actually helpful to our health, okay? I believe, Ms. Abramoff and Mrs. Smith, that it was a law on the books, that rentals were not permitted in Howell Township. We know that that's
illegal.
There's a lot of things still there, but we also know that that's not the way it is, okay? There are rentals in Howell Township all over the place.
And
yes, there are. Okay, so.
Mr. Bayer, also, at the prior hearing when we discussed this matter, you had discussed a situation in either Little Falls or Little Ferry, and I believe Mr. Howell had also read that opinion and was able to cite from it as well. I think it would probably be important for you to just explain what happens if we were to have gone the course of of just saying to the wind with COA and we will fight in court. What could happen to us?
Well, the pinnings of the Mount Laurel Doctrine comes from the New Jersey Supreme Court, and basically what the Supreme Court did as a hammer against municipalities is create what's called the builder's remedy. And basically it says that if the township or municipality does not provide through its own land use zoning ordinance its fair share of affordable housing, an owner of property or developer can come to the court and ask the court to set aside the municipality zoning ordinances to allow for high-density residential development with an affordable housing component. In the case of Little Ferry, it was a case that's a highly developed town along the river in Bergen County, and there was a property owner who had an existing garden apartment complex which amounted to units at about 25 units per acre. That town was a recalcitrant town, had done what was suggested by some of the objectors here today and said they weren't going to do an affordable housing plan. And they were ordered by the court to do one, never did one, and ultimately the court imposed a builder's remedy which allowed for a high-rise apartment complex at 75 units an acre. So the threat is that if you have a landowner who is willing to provide for affordable housing, you will get density. The density here, by the way, if the zoning is implemented, is approximately overall 9 units an acre overall, and you will get densities at anything
I
from.
subtracted the commercial piece.
How many acres are there? 28 acres?
28 acres, but I subtracted out the commercial piece before I did the calculation. I'm sorry. I subtracted out the commercial piece because there's an area that's dedicated for commercial along Route 9. So I didn't want to mislead you by giving you density numbers that are, contemplating that as being as part of this development when it's not. So I subtracted that out and then did the calculation. It came out to be about 9 units an acre.
You will, and what I was trying to say is through a builder's remedy, as evidenced in the Little Ferry case, you're going to get densities far greater than that, and talk about destroying the character of Howell. And secondly, you're going to get them in locations where where the planning board or this governing body may not particularly think it's a good idea to have them. You are going to lose control of your zoning regulation. That is what at risk. And while these are all, and believe me, I understand that this is a choice. These are always there's two bad choices. There's not a good choice you're facing here. So the answer is do you make a decision which limits your risk and liability and puts away the risk that you're going to end up with a higher density development in a location from a governing body or planning board perspective where you don't want it. And that's ultimately the decision that we're all facing here tonight.
Listen to the president the other night say he makes all the decisions, whether it's a bad decision and a worse decision. Okay? Let's go.
Mr. Dalton, Mayor, if I could, Mr. Dalton, just to further on what you just said, so that people understand, Little Ferry was built out. There's nowhere else to build. So the guy who won the builder's remedy lawsuit owned the two-story garden apartment complex and was allowed to tear it down and then build the 70-foot high-rises on that property. So it wasn't like he had an empty piece of land either. He had existing structures there that were affordable housing, but he could increase the affordable housing on his site. So that's why the court granted him permission to tear down what he had and put in buildings that the town wasn't prepared for.
Absolutely
the town
correct.
with one school doesn't even have its own high school. And they got destroyed because they didn't believe that the court would side against them. Kind of like I believe what happened in Roosevelt too, where Roosevelt's a town of how many hundreds of people and got nailed with a 254 unit obligation because Toll Brothers filed a builder's remedy lawsuit against them?
Yep.
Roosevelt's not far from here.
West Windsor's another good example, Mike. Yep.
Sir, name and address, please.
John Smith, 113 White Street. The only thing that I really have to say tonight is that the 5 of you are going to be remembered for this. what you do here. And I know that all 5 of you are deeply, deeply aware of that, but you are going to be remembered for years for either standing up against these people and getting together with other towns and trying to figure out a way to fight this COA, or you're going to be remembered for caving in and selling everybody out. And that's really what's going to happen here. You're going to be remembered for years and years and years, either in a good way or in a bad way. And that's where I don't have a question. I just had a statement, and that's it. And I wish you luck, and I hope that you do a good thing. All right?
God bless you. Thank you. Next, Mr. Shevitz.
Mr. Bears, this is the 3rd round of COA?
Yes.
So I'm going to imagine that towns have been fighting COA mandates for 3 rounds. And how many years would that equate to?
The first round started in 1987. It was 87 and 93 was round 1. So it's 22 plus years now. And I would point out to you and to the public that there's actually now 23 lawsuits challenging COA's 3rd round regulations, including one brought by the League of Municipalities. Towns are not lying down and taking this. So it's a question of fighting, but at the same time protecting yourself. That's sort of like you're sort of working at you're working at 2 fronts at the same time.
Mr. Mayor, I have a question for Mr. Bear. Has anybody ever been successful fighting this?
Well, when you say it, the answer is that I will tell you that as of, this is 9, I would say within the last 3 years, the Supreme Court issued an opinion reaffirming the Mount Laurel doctrine. It was in the West Windsor case. So the answer is, you may be able to be successful in fighting a site, or a town has fought a site because the site wasn't developable, approvable, or you had some technical argument about how the regulations were applied to that particular town. But in terms of the doctrine, this doctrine is embedded or comes out of the New Jersey Supreme Court, constitutional doctrine coming out of the New Jersey Supreme Court. So even as Councilwoman Clark pointed out earlier tonight, they'd like to, and there are many people who want to abolish COA, and I think that's a pretty sound idea. But the issue becomes, it's as a lawyer who works in this area, it unfortunately, I don't think it's going to go away because this comes out of the courts. I mean, this came out of the courts before COA existed. The legislature created COA in response to the Supreme Court decision in Mount Laurel. So, then you're going to have another fight, assuming COA was abolished. But, so the answer is that an affordable housing, every town has an affordable housing obligation, and it arises out of the constitutional doctrine from the New Jersey Supreme Court. And I don't think that is going away anytime soon.
So without the COA for Howell Township and having the affordable units there, if we deny this, or Howell Township would just be open to builders associations for Howell being a pot of gold to build anywhere?
If any suburban town, especially the town like Howell or any town in Monmouth County where before the economic crisis things were, in terms of real estate development, good, you're extremely susceptible, yes.
Thank you.
Mr. Shevitz?
Elizabeth Nuskevich, 150 Maxim Road. I will not be able to speak as eloquently as Mr. Liston did, but I would like to say ditto to everything he spoke of. I've been fighting to get larger lot zoning in Howell since 1975. I really object to you taking 2-acre parcels and putting the density up and backing up to these people who have lived here for years and years and led the type of lifestyle that they've wanted to. I think it's changing their whole mode of life, and I would like my tax dollars to go to fighting this whole thing. I know you say you can't do it, but it's never over till it's over. We've fought zoning cases that were supposedly in the bag, and throughout the years, they've turned around, and we've had help fighting them from the township, and it's worked. You have to keep in mind that every time you bring in the affordable housing, you make it more unaffordable for the people that live in the modest houses in Howell. So we're in a catch-22. We might as well fight. I mean, there are so many people that live in my area that are in two-bedroom houses that are just hanging on. They're affordable, but if we bring all these kids in and the taxes go up and up and up, it then becomes unaffordable for them. And they'll be in line for affordable housing. So I just beg of you, stand up and fight this, because this is not in my backyard. But if we don't take a stand along with the other towns, it will be in my backyard eventually. It will just creep and creep and creep. That's all I have to say. Thank you.
Ms. Feigruber?
Suzanne Weingruber, 25 Princeton Drive. A couple things before I talk about some of the discrepancies or actually differences I found in the MOU, the ordinance, and the housing plan. That ordinance that Mrs. Abramoff and others, Mrs. Smith have talked about concerning the no rentals went by the wayside, I want to say, around about 1983, somewhere around the time of the Mount Laurel decision, which was, what, 83, 84, somewhere in there. And so that did go by the wayside. And I know how hard a COA plan is because I was involved with the first one. I wasn't involved in the original planning of it, and unfortunately we had a township committeeman who was serving as mayor, signed an agreement with the developer, and COA kept us to it, even though the governing body did not pass a resolution. And, you know, that's why I think there has to be a lot of care in constructing these things. And in terms of getting a plan in place, I think I said I was happy that we met the December 31st deadline. However, like other people, I didn't know the changes to the AST site because there was only one copy to be read down at the engineering office. It has gone online in the last day, so now people can read it, and it's a little bit after the hearing fact. Had we known, I think you would have seen people question it and probably present solutions and compromises that they might have been able to live with. I had a question for Mr. Baer. You talked about the committee of planning board, council members, and professionals. When did those meetings commence, and when did they end?
They started probably last spring or winter and ended in,
Winter meaning 2007.
No.
Last spring meaning
We're in
2008?
9. We're in 9.
We're in 9.
Last year.
So they started last spring 2008.
I would say winter, spring.
January, February, March.
No, probably March.
March they started?
Oh. Well, there was the initial meeting early
No,
on.
the initial meetings, that's what we're looking
And
for.
then there was, but the committee itself met more frequently in the fall, I think. And then it ended probably in November when the draft plan was submitted to the planning board around that time.
And when did the committee finish its work in terms of what the plan was going to be, their recommendations to council and planning board?
It would have been around the time, within the weeks before the time, because the planner had to prepare the document. So it was probably
October?
What I'm sorry, Jennifer could probably answer this better than I. But.
Mrs. Beam has a better recollection.
Yeah.
She was part of that committee.
And she also drafted the plans.
Initially, this was undertaken by the Master Plan Subcommittee, who looked at a variety of things. However, they didn't discuss particular block and lot information at that meeting. The committee that Mr. Bayer is referring to, we had come to the governing body to ask you to facilitate setting that committee up in the spring, but we actually didn't start meeting, I think, probably until late September, early October, and we met as late as November 12th in terms of finalizing the documentation, and that was primarily because even though the rules were adopted in June, they were subsequently amended in September and then further amended in November. So we were trying to hit a moving target. So when it became apparent that November amendment was going to be the last amendment prior to the December submission. We got together again, we looked at it, and that was in mid-November, I would say the 12th or 13th, right about the same time as the league, because I remember working on this while down at the league in order to meet the submission deadline. Oh,
Thank you, Mr. Costigan.
I'll pay for a chair if we need an extra chair.
I thought you looked exceptionally short tonight.
Thank you, Mr.
So
Costa.
so basically, I would say, and we only, we met several times, but I would say October and November we met, and then the draft and the plan was finalized, almost right up until the day of submission.
And that submission was,
November 21st, 2008.
it's signed November 20th. It had to be on file 10 days before?
10 days before, so the 21st was the 10-day before. It was on file not only here at the township, but it was also on file at the county, which is part of the master plan notice requirement. So it was there as well as of November 21st.
But there was
Hand-delivered
only
on the
one
office.
copy, and there was only 40 hours worth of time for anybody to review it. That's not your fault, but
Is that November 21st or December 21st?
November
21st, it was on file.
It had to be
at
on
Barbara's
10 days
office,
before December 1st.
as well as at the county.
And wasn't that available? I'm sure you have it on a disc in your office.
Actually, I don't have it on a disc. I actually had to scan all 215 pages in pursuant to some request to put it onto a PDF, which sounds easier than it is because of the graphics.
I know how
Yes,
to do a PDF.
But we
yeah.
did do that. The document size is significant, so we couldn't just email it. I mean, that was a problem. So we did put it on a disc pursuant to the request of the manager and submit that, provide that to her.
And there was no thought to put more than one copy on file for people to read?
I mean, we noticed pursuant to the municipal land use law, and that was, and
We
I
didn't
will
have
say-
a line of people that were requesting to see it, or we would have.
I would also say, and working with the manager as well as Mrs. Capitan, we did supply a number of additional copies before the end of last year. Through, I remember bringing the box to the planning board.
But the important date was December 1st because that was the hearing. So, I appreciate that. I know somebody told me they got a copy after the hearing also. But the AST change was never discussed publicly, at least what I went through the minutes, that there was no public discussion, was there? Well, I went through
Except
the
for
minutes.
Go ahead. Except for at the public hearing.
Except for the public hearing, it was never once discussed publicly, so the public had no knowledge, like in the past with the old MOU in 2006. That was out there publicly, and that's why the planning board voted the zoning down when it was proposed. And if you recall, the planning board did not agree with that MOU in the end and did not vote for the zoning to accommodate the MOU. So that's just the difference here, is that there was, and I thought maybe I missed something going through the minutes, but I couldn't find anything in the council minutes or the planning board minutes where the change to the AST site was discussed. And I just wanted to make sure that I hadn't missed something. Okay? Go ahead.
You're
I'm sorry.
talking about prior to the planning board hearing?
Yes.
Correct. It was not discussed at the planning board meeting or at the council meeting prior to the public hearing on December 1st.
And
It
then
was,
December 16th. There was a hearing before this council on December 16th where the affordable housing plan was approved.
It was approved, but there was no backup to that council item, because it is a 215-page document. I'm assuming that's why, and Mrs. Beam has told us it wasn't in a digital form. Normally there's backup to different ordinances and resolutions, and that didn't occur. I'd also like to know, when did AST suggest this change? Mrs. Beam?
I recall the first time I discussed it was probably beginning to mid-November. I know that even to date, we receive inquiries as to being included, so it was, mid to late November, because I don't recall.
Well, it couldn't be
It was
late.
prior to the submission, but it was probably mid-November that it came up, because I remember the first several meetings of the committee, we didn't discuss it, but the meeting subsequent, we did discuss it, which was the 12th of November. Yeah. Right.
So AST decide, before the 12th, they asked to be included, and this was just like a last minute? You'd been going through these meetings since the spring?
Yeah, and actually, and we required all submissions come in through the township, and as you can recall, in the manager's office, there were several requests that were coming in like the day of the meeting. People were emailing and faxing documents in for consideration. So there was no deadline as to when people could and could not submit their inquiries. But in looking back through my calendar in anticipation of questions like this, I noted that it was probably, it was around just before that November 12th meeting, because that was a new project that was brought to the committee at that time.
And did AST threaten a builder's remedy if they didn't get what they want?
Not to me, they didn't.
Okay, so they didn't threaten a builder's remedy. That is good to know. I appreciate that information. There are some differences between the MOU, the ordinance, and the housing plan, as I mentioned. In the MOU, it says that there'll be a 50-foot buffer on the Conover Street property line only. Very specific, says only. In the ordinance, it says there'll be a 50-foot buffer around the entire track. That concerns me, because are we going to wind up with a problem now that the town agreed, the council agreed to the MOU, and the ordinance doesn't agree with the MOU in that particular respect? It requires a 50-foot buffer for the entire tract, except where it's going to abut private or public open space, and then it has to be at least 10 feet. I'm not sure I'm happy about it being at least 10 feet. But if the MOU says Conover property line only, and the ordinance says 50 feet, you folks are the professionals?
When we looked at the ordinance, this issue came up at the planning board meeting when we reviewed it for consistency, and the ordinance requires the 50 feet around the entire tract, and that 10-foot requirement was in that ordinance from the last go-around when the back piece was going to be public open space, so it was a reduced buffer. This project will maintain that 50-foot buffer.
But that's not what the MOU says.
I can't dispute that. I'm just
Okay, so if we
referring to
can't
my involvement
dispute
with the
that,
ordinance.
Mr. Bear has the JD, so
Yeah.
let's let him tell us
Well-
what's going to prevail.
Well, the builder, when the developer goes to the planning board, the developer is going to be looking, what the planning board is going to be looking at is the zoning ordinance.
But what happens, he's got an MOU, he says you agreed to this, and in the MOU, it says you're going to pass an ordinance that comports with the MOU. So now we have a problem here.
Mr. Bear,
Yes.
in the original MOU from 2000, or the original agreement, because the original MOU was signed years before the original agreement, the original agreement on page 6 states that the project shall have, inclusive of landscaping and side yard setbacks, no less than a 100-foot buffer from the property line at Conover Street only. So that was in the original agreement.
No, yeah,
We
but,
just lowered it, so it's like I said before, if a guy's got something in his hand that says I can do this, he's not willingly gonna give you more. We're actually, it was discussed, voted on, and agreed to in 2006.
the difference in the 2006 is that 100-foot was provided in a buffer to Conover Road, and it doesn't speak, I don't know how he would have interpreted it, because I believe the rest of it says 50-foot for the rest of it. And,
No,
but
it says
but
the
my
100-foot
concern is,
buffer from the property line at Conover Street only.
Okay.
okay, the problem at this point, and I've seen the conceptual, the problem at this point is you have something in the MOU, and I'm wondering if this developer's going to come back and say to the planning board, tough luck, you can't make me put 50 feet over there. I mean, it's a valid question. Valid question?
Jennifer was just saying that the planning board is not a signatory to the settlement agreement, and what the planning board is going to be bound by is the zone. The planning board is not a signatory to the agreement, and what the planning board is going to be bound by to interpret and enforce when the application comes, if it comes, it would be the zoning ordinance.
Well, I hope you're right, Mr. Bear, and I hope we don't wind up in litigation concerning that, because I think, that's, one place that the township, may have a problem. The MOU also says that the AST, that this particular site will not have to comply with the community design standards that are in the ordinance. And I believe the ordinance does not say that. The MOU says that. Oh, yeah, I've read the MOU.
Actually, there was a letter sent to the attorney for AST from Santina Bombaci speaking directly to that, and I believe it was signed by the former township manager, Mr. Chinesky, which removed AST from having to
Well,
to
the public
comply.
has not seen that, and that would be wonderful if it could go on the website so we'd see that, but we're talking about the MOU that was just approved a week ago, and that MOU says no design standards shall be applicable, so I would think that this MOU should have, I would have hoped somebody would have looked at that, because, you know, AST has built some beautiful townhomes and single-family homes. I've also taken a look at their website, and some of their stuff is not so attractive. You know, it resembles, you know, what we all call the barracks down over there by the Route 195 interchange that's sitting on that, and that unfortunately was part of our first round COA that got pushed through and amended several times. So I wonder, the ordinance does not say that they do not have to comply with the design standards. So again, Mr. Baer, you're the attorney. Which one do they have to comply with? No design standards, or do they have to comply with the design standards? Because the ordinance differs from the MOU. I don't have the I don't have the MOU in front of me, but it says here. Oh no, that's the applicable fees. It says design standards in it. Hold on.
But they want the design standards.
Yeah, no, it's in here. I think it's even the commercial component is exempt, if I'm not mistaken. I'm sorry, I have it in my folder, but it is in here, because we talked about it. South Track. I think it's in here somewhere. I'll have to go back and find it, but I do know, and I will be glad to email it to you, Mrs. Bean, but I do know that in the MOU that I pulled off the website, that it just said the designs, it was not subject to the design standards, and Mr. Howell seems to have indicated that is the case. It also, the MOU, which I just saw, said that it is not, they are not responsible for any road improvement assessments. And the conceptual has the one and only entrance off of the jug handle, the Sunnyside Road jug handle. Okay, if people think that's going to be a wonderful traffic circulation, listen, all you have to do is go up to the Adelphia Greens, which comes in. They actually did cut a road there abutting the jug handle, so it's not quite so bad. But that's not what this shows. This shows you're going to actually come in the jug handle and enter through the jug handle into this site, not an additional road. And that's the conceptual. It shows Conover Road as an emergency exit, because in something, as someone pointed out earlier, in something this dense, you must have two means of egress and egress. So that, obviously Conover Road, if anybody's been down it lately, isn't in the best of shape to begin with. And to take this amount of traffic is going to be, the town is going to have to improve the road. You're probably going to have to increase the cartway also, because Conover Road is one of those older roads that just about lets two cars if nobody's parked there. And I see Mr. Memolo shaking his head because he's lived here a long time and he knows that street. So I'm concerned that the taxpayers now are going to not only have to pick up the cost of improving Conover Road, that in all likelihood you'll have to pick up the cost of improving White Street, because the developer now owns all that property along White Street, having purchased another property, and from what we hear, offers are being tendered on other properties on Conover Street. So there is access through that lot into the back of the development, and it's very quite possible that they may come back and say, all right, because I can't see DOT giving them access off a jug handle, not when Conover Street is there and White Street is there. I could be wrong, but I've been dealing with DOT for about 30 years, and I just don't see them letting that happen. That's not in their nature, and they try to limit all highway access, and particularly when you're talking about 220 units, let's just say half of them have a second car. I think there's a possibility even in a one-bedroom, you're going to see a lot of two cars. So let's be generous and say there'll only be 300 and, I don't know, 60 cars, okay? We'll be very, very generous and say there'll only be 360 cars coming and going, through that jug handle, both to get out on Route 9 as well as to enter into the development. I think and then eventually possibly school buses entering. So I do not think it's right that the MOU says they don't have to contribute to anything. When they came back to you and said, we have this idea, it should have been greeted as an opportunity to say, okay, you want to do this, then we want something in return. And I know the COA regulations, and I don't think it's unreasonable when there's going to be 180 market rate units that there is some consideration.
Market rate units, ma'am?
160 market rate units, then there's going to be some consideration to the township for what it's doing to its infrastructure. I would have hoped, they asked for 220, that if there was a need for a change, one, the public would have been involved in it, and two, there would have been some kind of compromise as opposed to giving them their 220 that they requested.
Mr. Baird, did they come in and say we want 220, or did they come in at a much higher number?
But they come in at
Oh, more than that. I think they started around 280, and actually
on the day before it was due.
Yes.
And what was the original number when the original MOU was
240.
signed way back in the day?
245.
The original?
The original was 245.
The original one that was signed?
By, yes, the former administration, the former mayor and council.
I
people.
thought it was for over 400.
I believe there was one for 350, I believe.
Well, I think they eventually signed one for 245, and then it ended up at
I'm just saying,
118.
I believe, I'm...
Yeah. I have a document that says 245, and then it went down to 118. It may have been at 350 to begin with. Another discrepancy I want to point out is in the housing plan, it includes Lot 88.02. That is not in the ordinance. How does that open us up for them to come back and say, give me 8802?
8802 originally was discussed, however, it's been removed, and there's an actual provision in the ordinance that says specifically that it reverts back to ARE2 zoning, so therefore...
And they can't come back at a later date and say, gimme.
Well, anybody can come back at any time and ask for anything. What actually occurs is unclear.
And can they point to the housing plan and say it's in there? No, I got the planner and attorney over
I
here.
mean, the question is that that's typically when you refer to master plan documents, it's in support of use variance or what have you. But as I had indicated earlier, the plan that was submitted to COA has to go through their regulatory review, and subsequent amendments are going to be made to it in response to their comments and questions, and those are things that will be reconciled and rectified at that time. And if I could just go back 1 second.
Go ahead.
To talk about the discrepancy of the community design standards, I think maybe it was backwards because it actually is in the ordinance, and I couldn't find it specifically in the MOU. It's listed under 5B, where it exempts both the commercial and the residential portion from the community design standards.
It's in the ordinance. I knew I read it somewhere.
And, wait, Jen, and the MOU actually incorporates the draft ordinance by reference as well. So the draft ordinance, as was ultimately presented here, was incorporated as an exhibit to the MOU, which had that provision.
Mm-hmm.
And Ms. Beam, just so that I get it straight, somehow the language was changed in the agreement from 2006, which put 8802 as part of the PMU.
Right.
So actually now that lot is actually going back to
Correct.
ARE2.
Right.
So the density is actually being lowered tremendously.
No.
In that
No, the
section.
land, the acreage is,
For that
If I could
site.
finish, it'd be great.
the acreage is being lowered.
Sorry, Councilman, you're right.
The acreage is being lowered. My concern is that it still sits in the housing plan. There's also a page in the housing plan, and I didn't bring all, because I didn't have enough paper to print out all 215 pages somewhere, and perhaps it's a typo, but on one of the pages it says the 220 units are going to be age restricted.
it is.
Okay, I didn't imagine that.
It's not, they're not age restricted. It goes back to the age targeted versus, and I agree with you, and
Thank you.
those are the issues that the little cleanup issues based on that have to be made, when we're addressing.
But somebody, if they had read it, could have thought that the 220 units were going to be age restricted. And it could be like another Surrey down.
Only
to
if
the
they read
villages.
that sentence only and not the other 215 pages,
Page-
which refer to
214
it
pages,
multiple
okay, yeah.
times as non-age restricted family rentals.
Okay. And in the housing plan, I read where we have a minimum of 212 rentals, and the town, but there are going to be 489 rentals total?
Well, the issue is, yes, there's a 25% rental minimum,
Right,
where you
I
get one
understand
for
that.
one credit. You only get 2 for 1 credit for rentals above that 25% for another 25%. So in an attempt, as directed, to reduce the overall number of units provided in the plan, there was a policy decision to maximize that 25, that up to that 50%, to realize the 2 for 1 credit. So we're actually realizing a 212 rental bonus. So we're getting 212 credits for no additional units. So that was the policy
But
decision.
how many, and I don't have the 215 pages in front of me, how many rentals? I thought I read 489. Perhaps I have that number backwards. Okay. I also,
Yeah.
what?
If you could keep it to this, because...
Okay, yeah, and it all has to do this. There's one more thing after
Because
this.
also, no, I just want to say
Actually,
something,
two.
Frank Gruber, is that we have to vote and discuss these other projects, okay? There are
Okay.
other projects that are going to be coming before us.
But this has to do specifically with AST. I just question that if it's more than the 429? Okay, thank you. The 429. And one of the things that I did email to council members and planning board members, and
I don't know.
back, you don't know what I'm going to say, so don't say, I don't know. But one of the things I did email right after the League of Municipalities was from the COA workshop, where they discussed the fact that you could get credit if affordability controls were extended on rental projects. And I specifically cited North American Drive, whose, I believe, rental control expires in 2010. And that is obviously, that was one of the round one units, round one applications, and it is 100% rental. Can you tell me?
We can only do that if the owners actually agree to extend their controls. We did look into that. This is actually something that we've utilized in other communities, and unfortunately in this particular instance, we were unsuccessful in being able to do that.
So North American Drive basically becomes non-affordable housing after 210?
Correct.
Wonderful. Go ahead, I'm sorry,
I
Mr.
was just
Bear.
going to say, in other communities, it's actually far easier to extend controls with owned units, but with rental units, it's difficult because if you have an owned affordable housing unit coming out of the second round, which would be ones that would be expiring around now or through 2018, those are ones where you can only achieve a 5% return above the restricted price because of COA's regulations. So in other communities, we've been able to extend controls on those kinds of units, but with rentals, it's difficult because the owners would rather have rents at market rate as opposed to affordable.
Okay, well, I hope definitely the town makes sure, because their payment in lieu of tax expires with that, and I certainly hope they're back being assessed at the appropriate income producing. The one last thing I do want to mention, and a gentleman brought it up before, is in 2003, AST began their discussions with Rubenstein about purchasing this site. This is all through public documents. In 2005, the Rubensteins had, as the gentleman said, ceased to farm. They actually were bringing in eggs from another site and selling them, and they had not qualified for farmland assessment. So in 2005, and I'm going to presume this was at the developer's request because they hadn't done it in several years, they filed a woodlands management ordinance, a woodlands management management plan and applied for farmland assessment. And if you're not familiar, if you're approved, that acreage is only valued at $80 an acre. They had to provide woodland, $600 worth of firewood in 2006 and 2007 before the assessment was regained in 2008. At this point, the 3 lots, which are specifically mentioned in the ordinance, have a value of $60 in terms of taxes. That's all they're paying. And on top of which, they claim they cut 4 cords of wood and they sold it for $600. The Woodlands Management Plan that was submitted originally by Rubenstein's calls for reforestation of the track. And the reason AST is still reaping this benefit is that a approved woodlands management plan stays with the property for 10 years. And while it was legal, it is certainly questionable, particularly since there has been no reforestation. I don't know who our new assessor is. I would certainly hope that the new assessor would get out and take a good hard look, because the fact is that the plan probably was filed. The Rubensteins had not qualified in some time. I'm sure they had no thought about qualifying because they were selling it. The Rubensteins were paying a little over $40,000 on their total tracks, which also included 8801. And the property subsequently dropped down to $60 for those 3 lots. And they will keep that as long as they keep saying they sold $600 worth of firewood. And anybody who's familiar with that lot, I looked at the Woodlands Management Plan, the area they claim is being reforested, there isn't even a blade of grass growing on it. So there is nothing being planted, and there's maybe 2 stumps, and I don't think you got $600 worth of wood out of the trees. And I certainly hope, 2 trees, I certainly hope this would be looked into. Those are my comments.
Thank you very much, ma'am. Mrs. Dixell, did you want to speak?
Good evening, Barbara Dixell, The Villages, Freehold. I want to talk about something with this property that has not been brought up before. Edward Liston, the attorney that was sitting here before, mentioned something that caught my attention. He said that this property is part of a watershed. Okay, if it's developed, if any of this building takes place, what is going to, I understand now, I've been told that the state of New Jersey has very strict stormwater regulations. Does COA or anybody from this property have to abide by New Jersey's strict stormwater regulations, or are they exempt from that also?
Nobody's exempt.
They're not exempt from the stormwater management requirements.
Okay, because if that property gets developed to the extent that people are talking about, what is going to happen with the recharge into the ground? These people have wells. We have to have drinking water. The township needs water. If it's a watershed, the streams have to be fed. People need, is there anything that can be put into any type of agreement that could tweak this thing that would hold the developers to some very, very strict regulations? Because as you know, Howell Township is the Manasquan River watershed. It's the Matineconk watershed. Howell is wet. If you've all seen the stream map, Howell is wet from one end to the other. We are going to lose. Some of these streams may wind up drying up. Some of these, the water doesn't recharge. If they clear cut trees, where is it going to go? Is it going to flood? Where is this water going to go? Somebody has to think of very, very strict additional requirements for this development, for stormwater regs, and for this developer to be held that we will not see significant damage all the way up to even the Manasquan, to the almost to the reservoir or whatever. I mean, if it's in two watersheds, and this property goes back, I'm sure, almost to the Manasquan River, the Manasquan watershed. If Liston is saying that this is in the Matinaconk watershed, well, you know what? They may have a problem down in the Matinaconk in the brick area also from whatever water gets used or recharged or something that gets taken out of the ground. So I want everyone here to really give this some very serious thoughts.
Thank you.
Thank you.
Thank you, Mrs. Dixon.
Can you just address that in terms of the requirements?
Howell Township adopted stormwater regulations mimicking the state's best management practices, and the required, there's a requirement for recharge, there's a requirement for retention, and then there's a requirement for the removal of solids. So I'm not really an engineer, but I will pretend to be one tonight. And because of the location of this project or property, they would be held to a very high standard of suspended solid removal. They're going to have to recharge, and so we have the same requirements that the DEP has on the books, and that will be imposed at site plan during that hearing process.
And may I ask also, the issues, the specific issues that people have in terms of traffic? I know I've brought this up every time. You know, I think people have valid concerns about how it's going to affect them. And tonight, I know we're not dealing with the specifics, but for some reason, if this is passed, this will go before the planning board. Am I right?
Yes.
And those specific issues can be brought to the planning board in terms of traffic, in terms of all of these issues that you're dealing with tonight that people are concerned about. I want to ask also Mr. Baer, just give me one moment. Am I correct that in addition to the public having input tonight, in giving us input how it's going to affect them, they can also go to the planning board if this is passed, correct? They can also, they have till I think it's April 23rd to contact COA specifically, and they can write to COA to object to this plan as well. So I just want to make sure that the public knows, you know, a lot of people are feeling helpless. They think that they don't have a voice in this, but you do. And those are specific things that I think that people can get out and do if they have some concerns about this. Am I right about that?
That is absolutely correct.
Okay.
The township received a completeness notification from COA that our plan was administratively complete. We published a notice in the Asbury Park Press as required by COA, seeking a notice saying that we're seeking substantive certification, which is approval of our plan. And any interested person can file an objection with COA. And that will be addressed through the if that objection is filed, it would be addressed through a COA process, which we would participate in.
And in addition, this going to the planning board, all these specific things can be dealt with, and there is certainly nothing in what is being considered tonight that deals with those intricacies on the plan, and that will all be addressed publicly, where the public can have comment and can have some, certainly, some input into that. Is that correct?
Yeah, as Jen pointed out, all these just because the cost-generative features were addressed in the MOU or the agreement, but all these site plan issues are valid issues which will be addressed at the planning board. And the developer will have to meet those requirements.
So it's not saying that they can't comply with DEP regulations. You're still going to have to comply with that. They're still going to have to comply with all of the ordinance that we have in place to protect the community. Is that correct? No. Just let me ask the question. I understand people are saying no. There's some specific exceptions, correct?
Yes.
And could you deal with those? Those are specific to COA that they're required to, correct?
There are exclusions that are identified within the agreement. The first being the cost-generative features would be like your tree replacement. And then the other exclusion would be the community design standards, which are specifically excluded. But areas such as getting relevant letters of interpretation or any kind of wetlands approvals from the DEP, any kind of flood hazard approvals, stormwater management, traffic, environmental impact statement, all those items that are required routinely by the planning board for site plan and subdivision applications will still apply. They're still going to have to make application, go through the technical review process with the professionals, and then have a public hearing at the planning board, which has that public process as a part of it.
I just want to point out, I'm sorry, that there's the affordable housing advocates that are, there's a real tension in Trenton between the affordable housing advocates and the environmentalists and DEP, because I will tell you statewide it's a huge issue. What has restricted, and many people will say this is a good thing, what has restricted the development of affordable housing or housing through the state are DEP regulations. And I was at meetings with 2 years ago with the Commissioner of the Department of Community Affairs, where they were saying they were going to establish a desk where COA was going to be talking to DEP, because all the COA people were frustrated by how DEP was slowing down all these applications because of they were imposing their stringent requirements. And guess what? It still goes on today. So it's nothing's changed.
Yes.
Ken Harper, 156 West 3rd Street. I just have a couple questions. Question one would be, are schools going to be able to hold all the extra kids that would be coming out of this? Or are we going to have to build more schools? Are our fire departments going to be able to handle all the more units, or do they need more equipment? Same thing for police and EMS. All right, that was my first part of it. That was the effect of the families in Howell Township. The next is it's 220 units and a commercial unit, right? Total.
And a commercial component.
Yes, this is going to be on sewer, right? So we're going to dump 220 units, a commercial unit, Simon Sports, because that was on the extension, right? All into the bad pipe in the Freewood Acres that we have discussed for the last couple years. Last year and a half to 2 years. Nobody even thought about that pipe cannot hold what it is holding now. We're just going to dump more into it. Nobody thought that would be a negative impact on neighborhoods surrounding.
They would still have to get, as you just heard Mrs. Beam state, a letter from Mercer stating that the capacity is there for them.
Well, Mercer believes...
Letter, hold on, you have to correct him. If they don't get that letter, they don't bill.
Okay, but Mercer already believes that there's, one, not a problem, two, that it can hold another 2 million gallons a day. There's a problem. And they're not fixing it, and nobody's looking into this. Mercer's going to sign that letter. That's a given. They see no problem.
Then you need to take that up with a Mercer.
Yeah. Bring that up with our Mercer reps. Mrs. Weingruber's a Mercer rep. Okay.
Yeah, I know this isn't the first you guys heard of this, right?
No.
Oh, because...
I know you well.
Okay, all right, because I got a little scared there for a second. I see some new faces. I thought maybe, we were reprogrammed or something. Forget.
No, you mean the problem that the
That
folks
exists
over
already.
there, yeah.
Yes.
But we're not aware that Mercer has said there's additional capacity in those lines
Well,
for
this
other
is from
people.
previous meetings of us and Mercer where they said that they can handle even more than they're handling now.
We can't hear, they can't pick it up if more than one person's speaking. Please.
That's where that was coming from. That was coming from meetings that we had prior to this, that they said they can handle even more than what they're handling now with this problem. So.
I'm not disagreeing with you. We just, okay.
All right. Well, I was just wondering because it's the township and, they looked into this, and I'm wondering if anything's even going to be fixed in it, or is the problem going to get worse for us, or has anyone... We haven't heard anything. We've made complaints. We've made complaints through the health department, which switched over to the sheriff's department, which switched over to Howell PD.
We're really here to discuss this. We can't talk about the problem.
This is part of it, because this is going to affect us more.
Okay, hold on. We've discussed Smith Street, 3rd Street before. There was a lot of testing done, okay? I'll be very honest, I don't remember you coming back before us since all that was done. If there's still an issue, please, let us know. We'll try to see what we can do, but, okay? I'll be very honest with you about this situation. I thought most of it was remedied.
No.
Okay, but, well, I would never know.
You did ask us to give you time. We're only talking not too
Okay.
long now, so
All right.
we were giving you
Okay,
time.
just
It's
so
not
we know.
remedied.
Oh, okay, just so we know. But I haven't heard from you since, is that correct?
No.
Okay, all right.
Well, you actually were supposed to hear from us since, but the health department, I'm sure, wasn't notifying you on the calls.
All right. All right, no
So-
problem. Let's try, all right, if you can, fine, whatever about this application, if you could, please. I mean, about
Okay.
this one.
I just, my whole thing was I wanted to know if this is going to be put in consideration with this, because this is more of a burden now on top of it, is what I'm getting to.
Okay,
Okay?
thank you.
Thank you.
Mr. Smith?
Don Smith, 54 Vanderveer Road in Howell Township. What really upsets me about this is how the residents of White and Conover Street got blindsided. The whole fair share hearing, there were so few people at that December 1st planning board meeting when the fair share plan was heard. The people, they didn't know their neighborhood was being impacted. I mean, this happens time and time again. You saw it tonight with the piercing and the tattoo. The people had no idea what was going on. The only way you can stand a chance, you'd have to be watching the website constantly to know what's going on, or coming to the meetings. I mean, you wonder why some of us come to every single meeting. It's just so we don't believe we can turn our backs on you for a minute. Something happens in this township. I mean, at one level or the other. So I can see where these people are coming from, and I would urge everybody in the township to write to COA and object to this plan on their own behalf to protect themselves, because I don't feel that their rights were considered with this plan. Now, the people on White Street and Conover Street, they have a rather unique situation. They felt rather comfortable when they were told that the front was going to be developed in accordance with the agreement, the settlement with ASD. So they sort of turned their backs on it for a while. They had no idea, nor did I, and I sit on the Environmental Commission. I never saw anything happen. I had gone to a lot of the master plan subcommittees. You're not allowed to talk if you don't sit on that committee. You can't discuss anything. It was done as a blind, what they called a blind matrix. And their reasoning was stated rather early on. If the residents knew the sites that were being targeted, they'd get all up in arms. It was a member of the planning board that made that statement. And that's probably true. But by the same token, if the residents don't know, if they are not a part of the process, they justifiably feel they have no control over their own destiny in this township. The master plan and all the zoning does state very clearly that the quality of life is to be protected. Whose quality of life? That remains to be determined. One big fear that I have with this project right now is that what happens if COA gets so many letters from these people and feels that, well, wait a minute, there might have been a problem, it was such a late entry into the game that the people may not have known, one reason or another. If they decide that we're not going to accept this into our COA plan, but you have an ordinance that gives this developer certain rights, certain development rights, and I don't see anywhere in that ordinance where it states that if COA doesn't back it anymore, they're not able to build this. Because we have had in this township sites that didn't end up being COA. COA backed out of them, but we got the density, we got that development. And the developer walked away with the biggest smile on his face you'd ever want to see. And I don't want to see this keep happening. And I'm wondering why this ordinance is being heard before the hearing, the public hearing date expires before COA.
That's a interesting. Yeah, that's an interesting question. I will tell you that.
Hold on, come on.
I like to be honest. I will tell you, and it's a double-edged sword, quite frankly. I will tell you that since I've been representing Howell Township in connection with affordable housing matters, I guess this is year 2 now. COA's general impression, and I'm sure the manager will back me up on this. COA's general impression is COA's been waiting to kick Howell out of its jurisdiction since I've been representing you. I could tell you that I've had numerous discussions with senior COA staff where they've expressed displeasure with me about, I would say, Howell Township's past practices, not the current administration or council. And that, like, for instance, came up in the context of the Elon discussion we had last year. However, what I will say to you is that under the COA's new third-round regulations, we now have to, every town has to provide an update every 2 years as to what growth occurred and where you stand with your plan. Here, I will tell you that if this is adopted, the plus side for Howell, in remaining in under COA's jurisdiction and avoid the draconian builder's remedy cases we talked about, is that you will be demonstrating to COA that I think, contrary to what COA's view of where you were in the past, that you are in fact serious in intending to meet your constitutional obligation. You have something in your plan right now called the Market to Affordable Program, which was a very, I think from a planning perspective, an ingenious reliance by Ms. Beam in putting it in the plan. And that's basically saying where you're going to be setting aside development fee money in your trust fund to help people convert who are interested in participating in converting their homes from market units to affordable units, but they would get a payment from the municipality to do so. And under the regulations, I think it's $25,000 or $30,000, $25,000 to $50,000. And right now, you have planned 180 units because COA allowed 10% of your plan to be market to affordable. I will say to you that by taking and actually approving a development that's an inclusionary development where you're getting a 28% set aside, such as this one, the objectors who are going to come to COA and say your plan isn't sound because of that market to affordable program, or if somebody would say that, is going to, I think in response to that, partially, we will argue, A, it's real, but more importantly, B, we are otherwise moving to produce affordable housing. We have good faith. COA accept what we're saying, and I think the adoption of this kind of ordinance is demonstration of your good faith. And I think it will help you in that process. And that's kind of the answer.
Anything else, Mr. Smith?
You know, that doesn't leave me with a good feeling, and all it does, it drives home Mr. Liston's statement earlier about Chamberlain and his Peace in Our Time. I don't believe in being the good little boy and going to the wall. I believe in fighting back. The other thing that has come up time and again, you keep talking about this being fought at the planning board level by the residents. The problem is you've already got criteria that establish the density he's going to be eligible for, his side yard, his front yard. You've pretty well got those things in place. What you're going for is very nearly a fully conforming site plan approval. There are outside approvals that have to be gained, Yes, we have no control over those, never did and never will. DEP, freehold soil, any number of outside, the New Jersey Department of Transportation. And believe me, they will want another road through there. And, you know, we're not going to have any say over what traffic limitations are going to be on White or Conover Street. And to think you do, you haven't sat on enough planning board or zoning board cases to hear the planning boards or zoning boards problems with traffic studies and what you're allowed to do with those roads. So, you know, there's a lot of other people in this township, especially those in Adelphia Greens, that are going to get hit the same way. And I hope that they're watching on television and observing what the people in this area are going through, knowing that they're going to be facing the same thing. Now, another question that I have, on the Environmental Commission, we just heard an application, they're a preliminary for a site of townhouses in the northwestern portion, and we asked them, you know, well, how are you going to contribute to COA? And the answer was, we're not. We don't have to. You've already gotten that covered in your COA plan. We're going to get all these townhouses, and they get off scot-free.
Is that a true statement?
No.
I hope not.
Hold it, Don. I'm asking that.
The town has on the books a development fee ordinance that would require residential development. I think it was amended up to 1.5% of the equalized assessed value to be contributed to the Affordable Housing Trust. So that, you know, which that would be a sizable amount of money, half at building permit, half at CO. That's that provision. I know that there has historically been, and I don't necessarily think it's been taken off of the books yet, our affordable housing ordinance that requires some sort of provision for affordable housing. And while how that's going to be implemented, quite honestly, is in flux depending upon how things flesh out at the DCA, I don't know specifically in this particular instance, but I know that the planning board has been requiring developers to go on record and say that they will comply with the ordinances that the township has on the books at the time that they're ready to go forward with construction. So I'm not quite certain with respect to that particular application, but I do know that there is a development fee assessment, and there has been and has continued to be requests of applications to make that statement, and those have historically and consistently, at least at the planning board level, been put into every resolution that we've seen.
We have an ordinance on the books, I believe, that requires inclusionary development. So
They say that they're not.
The guy that came to the Environmental Commission may have thought that, but I'm sure when he gets in front of Ron Tropoli or Ron Cachero,
It'll be going for the planning board. It's a planning board
he'll
case.
be made to understand otherwise.
Mr. Smith, I mean, you know better. They say. Doesn't mean that's the way it's going.
Well, you know, it's.
All right, let's say this if we can.
We have to take what what testified before us with some authority. I mean, before it goes before the planning board. And the thing is, what it comes down to, I don't know how the rest of the residents feel, but I'm getting a little tired of subsidizing this housing. I mean, they're entitled to new houses. I mean, this is getting ridiculous. If you set aside land, you could have maybe 50 by 50 lots, and what gets developed on that 50 by 50 lots, not affordable housing. They put a McMansion on it. There are ordinances that you can put in place. You can put a floor area ratio plan in effect, but it's never been done. We've begged and pleaded for it, and nobody ever seems to pay any attention. I mean, this has just gone on too long, and I'm just not going to beat a dead horse because there's a lot of other people that have a lot of stuff to say too. My main concern is what's going to happen if this site is dropped out of the COA plan. Is he still going to do like so many others have and build it, but no COA?
Anybody else?
We need a motion to go after 11.
Okay, how many more people do we have that want to speak? We're going to be here a while. We're going to take a break. Everybody. I need everybody. Listen, folks. Can we please? All right, there's different reasons why we need to get back after this. We have a little other business to do. I would appreciate anybody else that wants to speak, no problem. But please, if you could, only bring up things if possible that haven't been brought up before. These cameras kick off at midnight. At 11:45, we have some other ordinances we have to introduce tonight. Okay, so if you could, please. If you can't, you can't. But these cameras kick off at midnight. Is that correct, Ms. Slagle?
Yes, sir.
Okay? And it has to be taped. So, whoever would like to speak, please come up. If you could, keep it a little bit short. I would appreciate it. If you can't, whatever you got to do, you got to do.
Mayor, I'd like to make a motion that we extend the meeting till midnight.
And I'll second that.
I get a roll call on that.
Mrs. Clark?
Yes.
Mrs. Dalton? Yes. Mr. Howell?
Yes.
Mr. Memolo?
Yes.
Mayor Walsh?
Yes. Next. Mr. Sherman, how you doing? Name and address, please, for the record.
Howard Sherman, 384 Conover Street. I own from Conover Street to White Street. You've really got me scrambled. I don't know which way to go here. I agree with everything everybody said. We have a problem here, a big problem. Number one, traffic, of course. The kids in schools. So far, since December, the little house next door that you really can't see has been broken into 6 times. You're going to put all these people in the rental units. Tell me what's going to happen eventually. Maybe not tomorrow, but it's going to happen. The other thing is, the taxes they paid on that property don't even come close to what I paid. That isn't right.
Well, actually, Mr. Sherman, I'm sorry, Mr. Mayor, I don't want to interrupt, but I was looking on the Monmouth County website and I know that our CFO left, but it looked to me like they paid about $31,000 a year in taxes. Is that right?
That's correct.
That's correct.
$31,000
Well, why
a
did
year
it
in
come out in the
taxes.
paper that they were paying $81.61?
I think you got to ask the paper
Yeah.
where they got their sources, but I looked at on the Monmouth County tax website, and
We actually did a rough calculation when that was first brought up, and it came out to, I think,
I have
perhaps
it
over
Okay.
30,000.
Okay.
All right?
Yeah, I'm having trouble sleeping, and I hope you guys...
yeah, that bothered me too and that's why I wanted to look.
Okay.
Thank you, Mr. Sherman.
Thank you.
I have it somewhere.
Name
Good
and
evening.
address, please, Dave.
Dave Spitzner, 197 White Street. And first, I want to thank the council for listening to the public this evening concerning the development of the Cutler Rubenstein Farm. I only wish this debate could have taken place before this site was included in Howell's Fair Share Housing Plan, sent off to Trenton in late December. As the clock is about to strike 12 on our on our neighborhood's well-being here. I mean, this is it for us, and we know that. It has become apparent to me that scores upon scores of people impacted by this development knew nothing about it. It's also has become evident that these same people have great concerns about this property's development, ranging from traffic to environmental issues to impact on local schools. I've heard questions on how, after doing all the proper due diligence and researching an area, some of these people are buying a home in an ARE2 zone, and a project like this all of a sudden is impacting their quality of life so severely. I mean, these people have done their due diligence, have done their homework, making sure they locate in an area where, they're surrounded by large tracts of land. As for myself,
I struggle with the fact that I pay over $4,400 on 1.83 acre building lot, and I could build one house. And I pulled some tax information myself just to satisfy my curiosity. And I come to find out that taxes paid in 2008 on 3 lots that comprise over 7/8 of the egg farm site only brought in $71.78 in tax revenue for Howell Township. Now, this is 7/8 of the entire site, okay? And at 7 2-point units per acre, that can yield 176 homes for the builder. That's insanity to me, that someone's paying $70-some and can build 176 houses on this site, and I've got less than 2-acre lot that I pay $4,400 for and only can build 1 lot. That is insanity. And why we're considering rewarding a builder with this kind of density, you know, after it's, you know, it's obvious. You know, the people here know how that farm has been occupied over the last 10 or 15 years. We live next to it. You know, maybe they got their legal permits or whatever, but there's an unethical thing going on here. And to reward this builder is sinful. You know, and this is all after a settlement agreement in 2006 allowed, instead of a commercial component in the front and 7 units in the rear, you know, it rewarded it, it awarded an additional 118 units. You know, and the builder had an opportunity to sign that agreement, and he decided not to. He wanted more. You know, rather than being content with the town increasing the scope of the developer, the builder then refused to sign the agreement. And we're here today debating whether to allow the builder to increase the density of this agreement site by over 80%.
How do you, just over 80%?
Yeah, I mean, he had 118 units that was negotiated, so now it's going to be, you know, increased by 102 units. I think I believe it's over 80%.
Okay. But acreage is added, correct?
Excuse me?
But acreage is added, correct?
I'm talking about the site.
The site itself.
The rear part of the site would only yield 6 homes prior to any kind of zoning change on the 2-acre zoning. Once he gets his density, we're stuck with it. Even if the state deems his site inappropriate for a COA site, or if the state DOT has problems with all this traffic from the residential and commercial component going out on Route 9, you know, what happens if the state demands a secondary entrance or exit to be included in this plan? Does it end up on my street? Do we have to give it to him at that stage of the game after this is all approved? I think we do. We would have to afford him access to the property off of White or Conover or some other street. Do you have the answer for that?
Actually, we don't have to.
Can you just why the attorney, I'm sorry to interrupt you, but can you answer that?
Yeah. Jen, it's really a planning issue, but I don't believe you would have to. No, I disagree.
Okay.
Okay.
Good.
I think those are roads that are controlled by the township, and if the DOT permit is contingent upon a secondary access and the township doesn't permit that access, then the DOT permit would be.
So what happens to the
invalidated.
builder's density at that stage? That this is all about density. This is zoning.
I can understand your concerns, and I think, and I don't want to speak for anybody here except for myself, but I think a lot of what was agreed upon when the drafting of the settlement agreement was undertaken was that it was represented at that time, and it was appended in the ordinance and in the concept plan that was reviewed, that this would be accessed off Route 9 only. There would be no access off Conover Road or White Street, and that's reflected in the actual concept plan that has been provided to me. So I think that if during their DOT process, which I can tell you probably will take far beyond the local process, it's a long and detailed process, most planning board applications are conditioned upon an applicant receiving approval from the DOT. So that site plan application will be, based on no access onto White Street. If they can't get their DOT approval, then we're back to square one.
And the wording is such where this project wouldn't be allowed at that time?
Mayor, it would still have to meet all the criteria of the planning board. And because somebody tells you that this project would have to have a secondary road, doesn't make it so. Look, I would tell you, another example of this would be the development that was built across the street from Kelly Chevrolet. I would assume that the density is almost identical. And there's one way in and one way out. There's an emergency access, which is chained off, and can only be opened by the police or fire department. It can't be open, it's not a road that can be used.
Okay.
You look at Pineview Estates, I believe Wall Township approved 180 units there. There was one road in and one road out. The previous administration decided to put another road there. Wasn't required to, but they did. So, just because somebody's telling you that Route 9 access isn't going to be the only access that's allowed, doesn't make it so.
Okay. You know, that's one of my concerns, but, I mean, you folks on the council, I mean, what's your take on this tax situation? I mean, this...
But we need
I know you do, but I'm sorry, but I thought I had commented on that, and the township attorney had commented on it as well prior to you coming up. But I am looking at the real property tax list for 2005, and the 3 lots
Well, forget about
that we're talking
2005.
about paid $20,724, $23,192, and $83,0550. That was the 2005 tax.
Pull up
And I can-
2008.
I think she was getting there.
Okay.
Angela, or
All right.
Mayor, can I just make the point that this is clearly a valid concern?
But it has
Except
nothing
it's
to do
a,
with
it's really a tax assessor issue. Quite frankly,
It's
the
an
council.
ethical issue.
Well,
Well, I don't disagree. Listen, I'm okay that it's an ethical issue, but it has nothing to do with this. Okay?
I can't see how it doesn't.
Well,
How can you
I would like to-
give
I
this
would like-
builder another 102 units
if
when he's
possible.
paying this kind of ridiculous taxes?
Okay, if possible. Can we move on from the tax issue?
I'm
Okay?
sure you would like to.
Well,
Mayor,
it
can I-
has nothing
can
to,
I
it has, hold on. It has nothing to do with what I would like to.
Then let's discuss it.
That, I'm not, we have 15 more minutes and when we have to stop this. So if that's what you want to discuss for the next 15 minutes, I mean,
Are you telling me we have 15 more minutes and then you're going to ratify this?
listen, the
Without the public being heard?
Hold on. The camera goes off at 12. Go ahead, whatever you want to talk about.
All right, I'm going to yield to someone else, but I think the whole town should be enraged by this tax dilemma, you know, on this farm. Thank you for your time.
Mayor, if I could just say something. We keep being told we're going to reward the developer, the developer, I believe, at this point, doesn't own the property. He's a contract purchaser. Is that
He
true,
does own
or does he own it? They own it now?
Sunnyside
When did they
at
purchase it?
Howell
Sunnyside
LLC.
All right, you know what, I could probably hear if one person answers.
Okay. Now the developer does own the site.
When did they take possession of,
Okay,
when did they take possession of the site?
November '07.
okay. Mrs. Smith?
When the agreement was signed. When the other agreement was signed, they went from contract purchaser to owner. Is that correct?
That's correct.
Thank you.
Mrs. Smith? Name and address, please.
Pauline Smith, 54 Vanderveer Road. I'm going to do something before I ask questions and make statements, because I think it's, and I'm explaining because I think of myself as a humble person. I want to put on record my experience and training in these issues, because it might matter. Whether it matters to you or not, I don't know, but it might matter. I've been up there where you are. I've sat on council. I was on planning board for something like 15 years. I was chairman several years. I was chairman of the master plan subcommittee probably most of the years that I wasn't chairman. I've taken courses in governmenting courses in Ocean County College, land use and planning, and one particular course in COA. Those laws have changed since then, but I understand how it works. At Rutgers University, at Brookdale University, and through the League of Municipalities and New Jersey Planners Association. I have seen too many of these agreements go by the planning board, and I'm telling you, everyone breaks my heart. And please stop telling people they can deal with it at the planning board, because you will see, those of you that happen to be sitting on the planning board at the time, that whatever benefits the applicant, whether it be the ordinance or the MLUL, the stipulation agreement, everything is laid out in front of us and our hands are tied. Everything is tied up like a Christmas package with a bow on it. And the only stipulations made have to be made here by you before an agreement is signed and an ordinance is adopted. Like, for instance, that there be no secondary road, because you might think that that would be the end of it if one was required, and if you happen to be sitting there and refuse to give it. But you will find out that COA will hang over your head like the Tasmanian devil or something until you do. And I don't want to digress, but COA is nothing but a big bully, and Howell Township has done more than anybody else that I know of in the state of New Jersey to supply low and moderate and abide by the stupid COA regulations. It's been my experience. I've observed it, participated in it. Sometimes it's done some good, but most of the time it's done a lot of damage. And I'm asking you not to approve this ordinance, to hold it off. Mr. Baer never clearly answered Don's question, what the harm would be to wait until after the 20th of April. He gave an opinion of the benevolent COA, who are nothing but a bunch of developers taking advantage of all of us, and that's a fact. Educated observation, and I'm not afraid to say it. They can sue me, because then they can let them prove that they're not developers or representatives of the developers. It's a true fact. It's a true statement. And I'd like to elaborate a little bit more about the planning board process, because I am very angry. I've been angry over this situation for a lot of years. But I suppose I should set that aside to appeal to you, because, in my opinion, your whole process was flawed. Think about it. What was advertised for December 1st? A fair share plan. How did anybody know it would affect them? And when we got there, I was one of the few people. I asked a lot of questions. I made a lot of statements. And I'd like to share with you some of them and why I think it's deficient. One question that really put me over the wall. I asked if they had considered on each of these sites, and this, my question was for all three because it was a fair share plan, but it concerns this one also. I asked if they had considered specifically density and infrastructure and the impact having this density on each of these places. Thinking about, for one thing, the narrow roads like White Street and Conover and Wyckoff Mills Road and Southern Avenue. They're not fit. When I listened at the Master Plan Subcommittee to the makeup of their blind matrix, it didn't sound bad if everybody kept to those rules. But none of these sites apply. Sewer isn't everywhere. The roads are terrible. And the impact. I asked the question, and the chairman answered me. They had not considered the density of what they were putting in and the density of where it was being put. I think there are a lot of holes in this procedure. And I, for one, am going to talk to Telco. I'm writing a letter. There's a lot wrong. Do yourselves a favor and hold this off till the 20th of April. What's COA going to do? I can defend, especially round 2. Mr. Baer mentioned, it's gone right out of my head. I hate it so much. Elon. Our process was completed when Elon came along. So how would we misdeal with that? Mr. Baer brought it up. Mr. Baer brought it up. I'm using it as an example of COA. And why should we be afraid of COA? COA is going to make demands and be unhappy with us no matter what. Also, at that hearing, I was told I was shut down. I had a much longer list of questions and comments and why. I think we have a right to know why. As I have often said, and I don't know whether I've said it to this group yet, but I'll say it now, you have a right to vote. I have a right to know you know what you're talking about before you vote. So I ask questions. It's my way, as most of you know. But the chairman shut me down. He said, there are too many people to speak. Nobody spoke after I spoke or asked a question. Nobody. Does Mr. Baer have a better answer to why we shouldn't wait until after April 20th?
Well, I would disagree with your characterization of my last answer. However, I would also say there's a provision in the ordinance which says that this ordinance shall take effect upon approval, upon a bunch of things: final passage, publication, filing with the Monmouth County Planning Board, and approval by the New Jersey Council on Affordable Housing. So I would think it would be fair to say that unless and until that plan is approved or the objections are dealt with, the validity or approval by COA. Now it also says if necessary, but that's, so I think it's also going to be tied into the objection process is my point.
Does COA need to approve this?
Well, I don't think they need to approve the ordinance specifically. I think, though, that what that reference is really to in the ordinance is to the concept of, it ties into the affordable housing plan, which this ordinance arises out of.
And if COA says no, they don't want this in our plan,
Well,
what happens?
Well, I guess we could take the legal position. We could take the legal, now the developer's going to fight us, but that's fine. We could take the legal position that, based on that language, I think, that you don't need to, you don't need to implement the plan based on that.
That's never happened. I won't take up your time if some of you'd like to listen, and I can show you, and I'm sure Mrs. Weitengruber can back me up on some of them. Well, each and every one. That didn't happen. Though we were never, ever supported by COA. Never, not that I expect a pat on the back, but never given an okay for all we've accomplished. When have done some good things, we've had rehabilitations. Actually, we've had rehabilitations for years. We, let's see, in 1993, we put in, or was it 4? We put in a...
try to keep it to AST.
It is. This all comes down to it, because what I'm telling you is, and I know I hear it over and over again, that was then, Pauline, not now. Do you know how many times in the COA nonsense I've heard that? And it happens over and over again. We are taken advantage of. Now, why couldn't you, even if you don't wait till the 20th of April, why couldn't you amend this ordinance to give these people that live in the area a little comfort, make some better buffers, refuse an access onto White and Conover Street, that kind of thing? Why couldn't you do that? Because I'm telling you, the planning board's not going to be able to do it. And I've heard a dozen or more of these cases. It's appalling, and I literally was ill over it. And what you have to tell people, after you've told them, come to the planning board, they come up here and lay their hearts out on the table, and we have to tell them, I'm sorry, we're tied to this piece of paper. And that's a fact. Is there any reason why you can't make some kind of adjustment to make it a little easier on these people? Or are you totally unwilling to? That's your answer. Okay, then I'm going to go to the taxes, because it does affect this. Because there are, don't forget about the rollback. If they roll back to 60 whatever it is dollars a year, or from that, it's going to make a major difference. And you're dealing with an outfit who has been so unethical that they dream this up, but they haven't replanted anything, so they have not met the criteria for their forestry plan. So they should be paying full taxes. And if they don't go through with it, if they build in 10 years and haven't reforested, even if they're going to take it down again, that's what the plan says, that's what the law says. They should pay regular taxes. And I think that's within your right to do. And I also am concerned, and this is just food for thought. If this outfit put in a, whatever you want to call it, a letter, a request, at the 11th hour, so to speak, I question the wisdom of including them so quickly and making demands. It doesn't sound very good to me. It sounds pretty fishy. And as far as the 10 days notice, one more reason that I think that there are a lot of flaws in this whole procedure. Did you look at the 10 days? They started, the 21st was a Friday, before Thanksgiving. You're including the whole Thanksgiving holiday, including 2 weekends. That's 6 days. And I don't really think you can count the 21st, so it's probably 3 practical days, Thanksgiving week, when people are either away or preparing for a holiday. Is that fair for anybody to even find out if they were included? If your resolution is great, but it's empty, I'm sorry. You fight COA and you send resolutions.
Mayor, I would just caution you to leave enough time for discussion amongst yourselves with respect to the issue. Not that Mrs. Smith hasn't
Mrs.
said.
Smith can speak as long as she wants. She knows what she's doing.
I'm trying to get you to understand
Mrs.
you
Smith,
have to do
go
something
ahead.
for
Do
these
whatever you
people.
want. It's okay. You know the law.
Yeah, and I also know COA, and those laws are arbitrary and capricious, and somebody should have sued them for that to begin with, because you can't deal with them. Doesn't that impact any of you?
Mrs. Smith, you're not going to find out if you
don't let us
if you don't let us talk about it ourselves. You're not going to find out. I mean, but it's okay. Do it up.
Well, I'll tell you what. I could say a lot more, but I'll let you do what you think you have to do. Please remember, you have consciences, and there's a lot involved here. People's lives and property are destroyed, and it will cost all of Howell Township. And one more time, we put something so important in the hands of professionals to make the decision. It stinks.
All right. Anybody else in the public?
Right here. Mark Weeks, 1 Clearbrook Court.
Don't worry. It's okay. Thank you.
I have a lot of questions and a lot of comments I'd like to make, but I do want to ask the question that Mrs. Smith asked. What's keeping us from postponing this until the 29th? You didn't answer. You don't know. So in the interest of the residents of Howell and doing the right thing to keep people sort of, you know, copacetic here?
I think that was answered in two ways. One was it shows your good faith to COA. Two is that the ordinance is contingent upon COA.
How about showing your good faith to the citizens and residents of Howell?
But sir, the other side of the coin, and I respect everyone's opinions. My only job is the lawyer is to present what the law says, and that here and sort of the policies associated with it. But here, the issue becomes that every town, including this town, you could come up with a plan, and if you don't, I'm telling you that prior to the adoption of this third round plan, Howell was teetering on getting kicked out of COA's jurisdiction. The concept that you would show, the argument is that you would be showing the township's good faith that you're taking this for real, and that you're going to implement an affordable housing plan. It's not just a plan that's never going to be implemented, because at the end of the day, everyone says fight, 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 but then you're going to be spending a whole lot of time and money fighting this developer and other developers if you don't do it the right way. That's it. And at the end of the day, it's a township council policy decision as to how they want to spend their money and what they think's in the best interest. That's not for me as the lawyer to say. But I will tell you that it's expensive, lengthy litigation, and I've been involved in it, and then everyone's going to be coming up here and opering all the legal bills and saying, why are you spending all this money defending this litigation? And so it happens. It's just a fact of life. So there's, as I said before, there's really it's two bad choices, as the mayor pointed out. It's just sort of how they want to go with it.
I think we need to keep the debate going, you know, with you, Mayor, and the council members. I mean, I love what you said, Councilwoman Clark, about, you know, having the people come in, and, you know, that's important to you, and getting the dialogue going and getting the, you know, people's feelings out and positions on things, and that, you know, seemed to have had an effect on your decision on the tattoo guy. So I think this is a much more important issue. And, I mean, like I said, I'm sorry?
To you.
Well, to all of us. I think to all of us. And I'm speaking for, you know, any number of people who are here and not here tonight. So, you know, I would beg you. You know, I first found out about this. I've been a resident of Howell for 10 years. I first found out about this a few years ago through Carl Wisner, who, I guess, gave up the fight. But we're really not willing to right now. We want to have more dialogue, and that's all I'm asking for. You know, I'm tired too. We all are. You know, but I think you all, in your heart of hearts, want to do the right thing. You know, I've often wondered why the egg farm, why this particular site? Why are we so hell-bent on developing this site when there's other places? Somebody mentioned, you know, out at Route 33.
I think you have to understand something. We're not bent on developing anything.
Well, why can't we?
Where the property is. We don't have a housing authority. We don't put a nail in a piece of wood. It's not us. We don't.
Right.
I would imagine that I could speak for the other four people to my right. I would not want to see another house built. But the state of New Jersey doesn't afford us that ability.
All right.
All right, I'll leave it at that.
We got to move on.
Anybody else? Mr. Costigan? We're done.
Yeah. Yeah, just let them go.
Okay.
We're going to have to stop the meeting.
Go ahead, sir.
Good evening. I'm Michael Collier. I'm from 2 Clearbrook Court here in Howell. I don't know if it's I can even offer from the floor a motion to carry this to the next meeting. Well, I would hope, you know, the council would consider that. I come here tonight as a concerned parent, resident of Howell Township. I feel the mayor and the council's decision, if you let this happen, that the development of the Cutler-Rubenstein Egg property is being made without our best interests. The current residents of Howell, we're making it for 220 people that don't live here. My children go to Land of Pine School. I've read about the Southern School being closed. I've been going to the Board of Education meetings. I've been going to listen to all these meetings at the middle school about what we're going to do about the school budget. And we have to cut busing. We can no longer have after-school care. We can no longer have all these sports programs. All these different things that are being proposed so we can send our children to school. We just voted to close Southern School. 330 students, 31 faculty and staff. They're now got to be redistributed or laid off and throughout the school system. And now we want to put 220 more units in this zone here that's got to absorb Southern's, and if not directly, Newberry or Taunton's children being shifted to us. And then we don't even know what's going to happen to Ardena. If that closes, that puts even more pressure on this area of Howell. This property is the wrong property for this project. We talked about earlier, we opened up Councilwoman Clark with this fighting COA, and you talk about us going to planning board meetings and writing COA and having our voice heard. You're our voice. You're our elected voice. Hear us. You're to speak for us. You're the ones that are supposed to do this. Please, I beg of you, the mayor, you talk about you don't want to lose a fight with COA. Well, if we don't get in the ring, that's a forfeit. We never fought the fight. Thank you.
Mr. Costigan.
John Costigan, 214 Birdsall Road. I'll make it very quick. I'm very disappointed, extremely disappointed tonight. Not because what I know you're going to have to do. I know you're going to have to do it. I don't agree with it, but you're going to have to do it. But the backpedaling on a number of the people up here on, well, isn't it right? We'll have to do this so you can get out of, so you can whitewash some of the decisions you have to make. And I'm not going to even bring up the planning board because that was balderdash. They're not going to get anything from the planning board, so it was just a ruse, in my opinion, to keep the people a little more happy tonight. Or else it was ignorance on the part, because I've been around too long. That's all I want to say. And I will say one thing else. When Sharon Carpenter Migliaccio came to visit me, probably in 2001, she was told to see me for some reason, maybe because I'm a handsome guy. But I went and I called a fellow named Cox. He's an older gentleman, too old to practice much anymore. In fact, he's the author of the book, the Cox book, that everyone uses. He gave me 20 minutes of his time. He was kind enough. And he just said a couple of things, and he said, well, I don't do it anymore, and blah, blah, blah. But the point was that I said to Sharon Carpenter Migliaccio in 2001-ish, or two maybe, you got to kill COA. This is just a temporary bandage. You're fighting the fountains. You have to destroy COA. And the only way you're going to destroy it is what I said earlier. You need some governor up there. I don't give a damn if it's Democrat, Republican, liberal, conservative, whatever. They got to put 4 Supreme Court justices up there to change the balance of these whacks up there. The New Jersey State Supreme Court is probably one of the 3 most liberal in the country. California State Court Supreme Court being the first, and maybe the 9th Circuit Federal Court. But we're there. And they come up with all these little things that we have to suffer. And then you've got a preponderance of a certain party in the legislature that has cut down Joe Roberts, the Assembly, whatever you call him, Speaker of the Assembly, State of New Jersey Assembly. He's deciding that he's going to start pushing that we can't buy or sell, whatever you want to call it. It says sell our RCAs or sell part of our units to people that want them. So he's cut that off. This is an evil out there, and if we don't straighten it out one way or the other, it's got to be straightened out. That's all I'm going to say. I know you have to do what you got to do. I expected a little bit more, and I thank you.
Anybody else from the public? Tell her to close the public portion of the meeting. Anybody from the council?
Mayor, gentleman that just spoke said that if we don't get in a ring with COA, then it's a forfeit. Obviously, he doesn't, or he's not aware that we have been fighting COA for years in this town. We had a second-round plan that was certified by COA. And months after they certified the plan, they came back and said, we changed our mind, you're no longer certified, and they left us wide open. And that's how we wind up with these objectives being able to walk in and say, well, I want to include my property in your plan since your plan was not certified by COA. And COA never sits there. Even when they certify your damn plan, they don't protect you. As what happened with this, with the second round, COA went to the town and to the developer and said, mediate it and settle it. COA didn't say, no, Howell's protected by us. COA threw us to the wolves. And that's what COA does to every town. That's never going to change. It's never going to change. You know, there's other people that sit here and scream at us for not throwing tens of thousands of dollars into a pool to join other towns in litigation against COA. Well, you know what? I'm thinking it's pretty prudent on our part, because if any of those other groups get the COA decision overturned, all the towns reap the benefits of it, and we didn't have to spend the money. The mayor of Farmingdale sitting back there, he'll tell you, they had one COA lawsuit that came to their town. One. Cost them $250,000 for one. I think the list of objectives that had to get sent the notices of this plan was about 5 pages. Is that correct? We had to send certified letters to like 5 pages of objectives. So if one portion of this plan gets tossed, all 5 pages are going to say, I'm the one. And the folks from the area around this development are saying, well, why can't it be built somewhere else? Because what happens then is your folks stop coming, and that group comes and says, why can't it be built somewhere else? The state is telling us it has to be built somewhere. The state is also telling us that it has to be built near a major roadway. It also has to be built within walking distance to shopping. It also has to be built in an area where there's already water and sewer. Also has to be built in an area where there's mass transportation. There ain't a whole lot of places like that in Howell. I don't see New Jersey Transit buses running up and down Newton's Corner Road or Lakewood Allenwood Road or Randolph Road or Kent Road or Ford Road. Come to Ramtown, show me where you can build a development. Show me. You can't. There was COA sites in Ramtown, but that was back in the day when a builder could pay in instead and we could RCA the project out. We can't do that anymore. The sites that we can put these inclusionary developments in or these fair share developments in are limited. You know, somebody made a statement of, well, there's none near 524. Well, I'm pretty sure that there's a development that's COA inclusionary on the corner of 524 and Fairfield Road. Is that not correct?
That's correct.
Is there not also another inclusionary development on Fairfield Road itself at 33?
Yes.
You know? So that statement was an inaccurate statement. Cedar Glen, the development that I referenced earlier, with the density that is equal to or exceeds this density, was a COA site. It was back in the day when a builder could pay it out instead. But the density is greater. I believe it's greater. They have one road in and the same road out. There's one other access road, and it's an emergency use road only. So, I mean, there are ordinances in place. There's not anything in this agreement that said the developer can have another road. Is there anything in this agreement that I missed that says that they can have an access road on White Street or Conover Street?
No, and it's my understanding that the concept plan reflects that there's only going to be, that there's no access except for the emergency access, and that's it. And that the,
Okay.
All right, that's all I got, Mayor.
Anybody else on council? I have a motion from anybody.
Let me just, I know it's late, but I want to put this out. I mean, my inclination would be to give us more time to put our thoughts on it. I don't want us to rush.
Oh, I thought you had nothing.
But we're going to, in 2006, before this council was seated, this majority, there was an agreement and a resolution and a discussion, and this project was approved at 118 units, correct? Yes. So the difference is in the number of units, but this argument about the density, I mean, and 2 acre zoning being there, since 2006, we have all known that these blocks and these lots in this particular block were going to be higher density than 2 acre zoning. So most of the arguments I heard tonight really go to the genesis of the project and not to the additional density. I am concerned about affordable housing, the COA obligations getting control of us. I'm very concerned about that. And I've heard all the arguments, and I just don't see how we ever, at this particular point, beat back COA, you know, and so we lose control of it. And I'm not inclined for us to lose control of it. There are other inclusionary projects going in this part of town. You talked about Route 524. They're all they're up there, and I mean, look, this is not a positive thing for anyone. Nobody's in love with this project, but this has been with us, and this is an opportunity for us to get more, to minimize our COA obligations rather than having more COA obligations.
Anybody else?
No, Your Mayor.
You got anything?
Listen, I personally have been involved with this for a while, and you know, for me, decisions have to be made. I'm one who always believed in fighting, okay? But, you know, I also got to be very concerned for the town. When you have all these objectors out there that want to put a high-density building all around your town, okay? If we didn't put a plan together that we thought was defensible, this could have happened to many, many, many places. There's no guarantee that this builder didn't go into the courts and get 250, 300 built on this same exact spot. There is nothing that could have guaranteed that, okay? So, I'm not happy about it, okay? Yes, we were paying over $1.5 million for the back piece. You know, we also have Mr. Costigan asking us for money all the time to preserve more farms. I mean, these are not easy decisions. And I'll never tell you that I'm happy with some of the decisions I make up here. Okay? Some of these decisions I've had to make up here are some of the worst decisions I've made in my life. Sometimes decisions have to be made. So, it's a little bit tough thinking of the whole town. I mean, there are other projects going up in different places. On Fairfield Road, not far from my house, on Whitecroft Mills Road, on Southern. I mean, you know, we're caught a little bit on where they could go. And, You know, I've heard people say, we'll put them down in the southern part of Howell, over the country where they're near nobody. Well, you can't do that, and then I'm sure we'd have a different group of objectors. Can't put them all on 33. You don't have sewers there. Okay? There's a lot of issues in all different parts of Howell. So, somebody want to make a motion?
Now I'll make the motion that ordinance number 0-09-10 be finally passed and adopted, and that notice of its passage and adoption be published in the 32709 issue of the Asbury Park Press by reference to its title only.
Do I have a second?
I'll second it, Mr. Mayor.
Can I have a roll call, please, Mrs. Woman?
Mrs. Clark?
Yes.
Mrs. Dalton?
Yes.
Mr. Howell?
Yes.
Mr. Memolo?
Yes.
Mayor Walsh?
Yes. Okay, we have a little bit more work to do. Introduction of ordinances.
Hang on, let her be quiet, she won't hear.
All right, please. Please, if you could.
We'll just go in order from 9A1.
9A1. Can everybody please keep it down so they can pick it up?
Motion to introduce ordinance number 0-09-13 on first reading by title and to order that same be published in full in the March 27, 2009 issue of the Asbury Park Press, together with notice of its introduction and passage on first reading by title, and that it will be further considered for final passage
Could you please?
on reading by title, and that it will be further considered for final passage after public hearing at a meeting of the Township Council to be held on 4/28/2009 at 7:30 p.m. prevailing time in the municipal building.
I'd second.
Mrs. Woman, would you please read the title of the ordinance?
An ordinance amending Chapter 139 entitled Fees, Charges, and Costs of the Revised General Ordinances of the Township of Howell. Roll call, Mayor.
Would you please?
Mrs. Clark?
Yes.
Mrs. Dalton?
Yes.
Mr. Howell?
Yes.
Mr. Memolo?
Yes.
Mayor Walsh?
Yes. 9A2, repeal chapters 182, individual sewage disposal system. Could I have a member of the council, please? Make a motion?
May I make a motion that ordinance number 0-09-14 on first reading by title and to order the same to be published in full in the 32709 issue of the Asbury Park Press, together with notice of its introduction and passage on first reading by title, and that it be further considered for final passage after public hearing at a meeting of the Township Council to be held on 4/28/09 at 7:30 p.m. prevailing time in the municipal building.
Could I have a second, please?
Second.
Ms. Woman, please read the title of the ordinance.
An ordinance of the Township of Howell amending the revised general ordinances of the Township of Howell, repealing chapters 182 entitled Individual Sewage Disposal System and chapter 315 entitled Vehicle Operation on Private Property. Roll call, Mayor.
Would you please?
Mrs. Clark?
Yes.
Mrs. Dalton?
Yes.
Mr. Howell?
Yes.
Mr. Memolo?
Yes.
Mayor Walsh?
Yes. 9A3, create the position municipal housing liaison.
May I make a motion to introduce ordinance number 0-09-15 on first reading by title and to order the same to be published in full in the 32709 issue of the Asbury Park Press, together with notice of its introduction and passage on first reading by title, and that it be further considered for final passage after public hearing at a meeting of the Township Council to be held on 4/28/09 at 7:30 p.m. prevailing time in the municipal building.
Have a council president second.
Second.
Ms. Woman.
An ordinance to create the position of municipal housing liaison for the purpose of administering Howell Township's affordable housing program pursuant to the Fair Housing Act. Roll call, Mrs. Clark?
Yes.
Mrs. Dalton? Yes. Mr. Howell?
Yes.
Mr. Memolo?
Yes.
Mayor Walsh?
Yes. 9A4, to amend the structure of the police department to allow for an additional sergeant.
Mr. Mayor, I'd like to bring into motion here for this ordinance.
He's good.
Motion to introduce ordinance number 0-09-16 on the first reading title, and to the order the same to be published in full in the 3/2709 issue of the Asbury Park Press, together with notice of its introduction and passage of the first reading by title, and that it will be further considered for final passage after public hearing at the meeting of the Town Council on held 4/28/09 at 7:30 prevailing time in the municipal building.
Can I get a second?
Second.
Ms. Rowland, please read the title of the ordinance.
An ordinance amending Chapter 2-36 entitled Police Department of the Revised General Ordinances of the Township of Howell to amend the organization structure to allow for an additional sergeant.
Give me a roll call, please.
Mrs. Clark?
Yes.
Mrs. Dalton?
Yes.
Mr. Howell?
Yes.
Mr. Memolo?
Yes.
Mayor Walsh?
Yes. 985, amend land use violations and penalty increases.
Mr. Mayor, I make a motion to introduce ordinance number 0-09-17 on first reading by title and to order the same to be published in full in the March 27, 2009 issue of the Asbury Park Press, together with notice of its introduction and passage on first reading by title, and that it be further considered for final passage after public hearing at a meeting of the Township Council to be held on April 28, 2009, 7:30 prevailing time in the municipal building.
Can I have a second?
Second.
Ms. Rowland, please read the title of the ordinance.
An ordinance amending Article 19 entitled Enforcement, Violations, and Penalties of the Revised General Ordinances of the Township of Howell to amend Section 188-171 to increase the minimum violations and penalties.
Can I get a roll call, please, Ms. Rowland?
Mrs. Clark?
Yes.
Mrs. Dalton?
Yes.
Mr. Howell?
Yes.
Mr. Memolo?
Yes.
Mayor Walsh?
Yes. For information purposes, school elections will be Tuesday, April 21st, 2009, from 3 p.m. to 9 p.m. We have meeting dates. We have a township workshop meeting Tuesday, April 14th. And we have a regular meeting Tuesday, April 28th. Executive session for both will be at 6:30, with regular session starting at 7:30. Any other work? Anything else to do?
No, Mayor.
Oh, don't forget April 4th, Easter egg hunt, Echo Lake, no, Oak Glen Park.
Glen Park.
April 4th, there's an Easter egg hunt. I'll be there,
Be there or be square.
okay? Can I get a motion? Somebody?
Make a
Good.
motion.
All in favor of adjournment?
Aye.
Gotta do a roll call. Give me a roll call,
Yes.
please, Ms. Woman.
Mrs. Clark?
Yes.
Mrs. Dalton?
Yes.
Mr. Howell?
Yes.
Mr. Memolo?
Yes.
Mayor Walsh?
Yes. Thank you, good night, God bless, and drive safe.